Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇಲ್ಲ.
ಕೇಳ್ತಾ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು.
Tomorrow you take it to that. Sequential. I will say we take it up only on Thursdays. Thursday and Friday. Thursday. Thursday. Tomorrow. Thursday. RSA ಎಲ್ಲ Thursday ತಗೊಳ್ಳಿ ಬಾಕಿ ಎಲ್ಲ ನಾಳೆ. What is that? What is that? CL license ತಗೊಳ್ಳಿ. Yes. 2001 petition, Which petition is of the year? KVO. I forgot it. Yes, we'll take it, sir. After the preliminary, yes, after the preliminary hearing, we'll take it up. Thursday.
Well, 36. Well, 36.
Serial number?
36 minute.
20 is hearing on interlocutory applications. We will see when it reaches.
Page number 5, 27 to 29. Page 6, 30 to 30.
That pattern.
Page 13, 31 to 35. Page 14, 36 to 39.
Well, 36.
Yeah.
I appear for the respondent. I have informed Govindraj 10 days time. I kindly, the first time it has come.
Have you filed your statement of objections?
I have filed statement of objections, my lord, but first time it has come. So I have informed Mr. Govindraj, he has agreed. 10 days time I kindly begin.
List of from Shekhar, Lieutenant Counsel appearing for the responding. This matter after 2 weeks.
Much obliged.
Page 15, 40 to 47.
You have filed wakalat for the party in person. What is your name? So and so counsel submits that. MBN for R2. For R1? You said for R1. There's a party in person here. So you're filing wakalat for R1. When did you file wakalat? When counsel so and so submits that he has filed power for respondent number 1. Registry to indicate the name of the said counsel in the cause list. At request of so and so counsel, this matter week after next. 40. Training matter. We call this matter after 4 weeks. 40. No, he mentioned 40 itself, right? 40 at request of the petitioner counsel. This matter after 2 weeks.
16, 48 to 59, 17, 56 to 59, 18.
Value is in the hearing on interlocutory application. No, we will see. It will come. We will call it right now.
So, this matter is number 1. Yes, Naveen.
First deposit. Then first deposit. You have to deposit first. We'll give you some time to deposit. Then we will think of. Even before the appellate tribunal, you have not done it. And you have saved yourself for how many years there? How many years there for the appellate court, appellate authority? 1 year, 1 year there. You spend 1 year there without deposit. So the appellate authority said the petition has to be dismissed as not maintainable. See, you have no audience without deposit. Entire amount. Before the appellate authority pay the entire amount, right? First deposit, then we will see. When the counsel for the petitioner submits that the petitioner would deposit the tax amount demanded by the 50% of the tax amount demanded by the respondent number. By respondent number 2, if some reasonable time is granted. But such submission is recorded. Petitioner is granted 2 weeks time to pay the 50% of the tax amount. Yes, first pay, then we will see. And first pay. Then adana admane. Of the submission, the review notice issued by the second respondent at annexure F and F1 for the proceedings. For the proceeding, first went to annexure F and state, subject to the petitioner depositing 50% of the tax amount within 2 weeks. Failing which the petitioner would not be entitled for the interim order. SCGP SCGP to accept notice for respondent number 1. Copies are served upon it. 2 weeks to be deposited before the respondent number 1.
Doctor by profession. The connection here is the improved order by lot at page 24, page 17. I have filed objection to the renewal of bond and bar and restaurant license, my lord, by maternity home, nursing home of maternity home situated adjacent to the bar and restaurant. In spite of my objection, the authority has reviewed the list.
This comment. How was that you give permission for running a bar and restaurant which is beside an hospital? No. Hospital is hospital. Whether it is 20, 30. Correct. What does rule 5 say? Oh.
Nothing more of nothing to the beds, my lord. I have filed from Karnataka State Pollution, what is the capacity of the hospital? At page 33, my lord, of my petition,
Page 33.
page 33. A corrigendum as issued by the Karnataka State Pollution Control, that is preamble, my lord, that they have said, they have earlier given it is a 20 beds, they have issued a corrigendum, 30 beds hospital.
When was it issued? When is the date? The date of issuance Vaga corrigendum.
I have it.
There's no date mentioned there.
Anxious.
Really don't. Let him take notice. You take note. See, if it is with 30 beds, rather it is an hospital. And it is an hospital. Maternity hospital. The nursing home, it's available, private nursing home. Then you bar and restaurant, if bar and restaurant is being run beside an hospital, what would be the consequences of the patients? They would be there, all the patients.
Only one.
Will be accompanied. No, they have given objections. They have signed their objection
I have issued the objections to the advocate.
by Monday. You take
I
notice
have
for
submitted to issue some notice by hand summons to the third respondent. They await the list.
CGP to accept notice for respondent number 1 and 2. Issue emergent notice to respondent number 3. In addition, petitioner counsel is permitted to serve the take out hand summons on the respondent number 3 and file an acknowledgement to that effect. And SCGP to get instructions. This matter on 18.
The cases. Petitioners are.
What is this primary connection?
Primary connection is 11,000 volt that was being drawn just about the open well that is presently operating here. It's only the what
Who has to consider your representation?
we are already given the representation.
Who has to consider?
R3 and R4.
So who appears for this R3 and R4?
We already served the copy to all the respondents.
Devraju. SCGP to accept notice for respondent number 1. HV Devraju to accept notice for respondent number 2 to 4. Petitioner counsel to serve the writ petition papers on the Leonard counsel.
In the disposal, R3 R4 should not be proceeded.
Let us see. List this matter on Wednesday. Who has to consider your representation?
Small number 4 and 5.
Then five.
And then this passes through the land belongs to the petitioner.
Yes, madam. What records will you secure? You were directed to accept. Now, what is your representation? What is your representation? It's regarding what?
Payment of the damages comes of the that has been ascertained by the agriculture department. And it's, 24,000.
Annexure?
Agriculture. Getting them to the loss of crop. The loss of 1,70,000 and 1,78,000. The amount is also not paid. 2022.
Yes. We take notice now. SCGP to accept notice for respondents, all the respondents? For all the respondents? Correct. You accept notice for all the respondents. All the respondents. Kaveri ne. That is what this court asked you. Yes. Who, any standing counsel? So the representation has to be considered by whom? Five. SCGP to accept notice for respondent number 1 to 3. Issue emergent notice to respondent number 4 to 6. Returnable by. 24. Extension. Letter has been received by from the presiding officer, Industrial Tribunal, requesting to find for disposal of the reference number 16 of 2009. Time is granted. Another for the 4 months time is granted. For the
Much obliged, madam.
officer.
It's was listed on the last of the.
What is the rectification?
I served a copy on the opposite terms. I tried to reach him on phone and also tried to notice office was locked. But sent him sent the copy through postal acknowledgement has also been the office objection may kindly be overruled.
Did you mention in your presentation form that the copy has been served upon them? Where is that acknowledgement for having served the copy? And how is the court, how is the office supposed to know all this? You have to make an endorsement to that effect. Petitioner is granted a week's time to rectify the office of as requested. Yes, you rectify.
In serial number 7, my lord, I appear for the petition. The matter was listed on 4th, my lord. Your lordship has granted 2 weeks' time. I don't know why.
For 2 weeks time, particularly. What are the line? What is the alternate? What do you mean? 2 weeks is already over, Mr. Harish.
My lord, on 4th it was listed.
4/9.
Yes, my lord.
4/9. It is court on 4/9/2024 has granted the petitioner 2 weeks time to pay the costs imposed by this court on 10/2/2023. The petition is listed before the expiry of 3 days. Hence, call this matter on 18th.
Much.
You have to amend.
Not serial number 8, I appear for the respondent number 1 and 2 in the connected matter. Not this for non-filing of the this amended petition is going on from March. Amended just for is going on for amended cost title from
Filing amended settle now. Amended counsel for the petitioner. You amendment cost title ಹಾಕಿದ್ದೀರಾ?
No, I am filing the petition number 1 and 5. To withdraw the petition.
Withdrawing the petition.
Yes. Because Wakalat is already filed. Registered, my name is also sufficient.
And what about the other petitioners then?
He is representing another council.
Is now who's filing the amended cost title? Learned counsel, so and so appearing for Gopala Krishnamurthy. As he is filing the amended cost title.
Withdraw the
Who's taken
petition number 1 and 5. Petition 1 and 5.
Is here Wakalat. Earlier who was appearing? Gopal Krishna Swami.
No.
Who was appearing?
Very nice, right? The no objection.
Earlier, who was the counsel appearing for petitioner 1 and 5? Maruti, yes. So you are filing Wakalat. And for memo, where is the memo for withdrawal? Is petitioner number 1 and 5 present? Allah, they are present before the court. So other petitioners, they are not willing to withdraw. There is no memo. Password. ಎಲ್ಲಿದೆ? Memo ಎಲ್ಲಿದೆ? ಕೊಡಿ, memo ಕೊಡಿ. See, to take the signatures of petitioner 1 and 5. Password.
and basically the petition itself is not maintainable because they sought for a minimum wages seeking for minimum wages. They did not even approach the respondents. They did not made any request before the respondents.
Is now that petitioner number 1 and 5 are withdrawing,
Please,
let them withdraw. So against the other petitioners, they will hear the petition.
please.
Pass away. Petition of whose name? Right? Why were you made as a party in this present petition? What is the ground urged against you? What was there before the labor court? Second of February. What was challenged before the labor court? Was it under reference or was it a claim statement? What was it? What was
It was
the
a
reference?
reference.
Huh. How is respondent number 2 a necessary party here?
The petitioner, respondent number 1 is employed with the respondent number 2, not based on the contract or the agreement with the petition fee alone. The corporation has called the tender method. Some so many divisions, they are the successful bidder of the by name Madhuri and Madhusudan and Srinivas and chartered accountant before. They have appointed some their colleagues, and they left them in my offices for maintaining the ledger extract. Based on that, they work with us, and the payment was made by the chartered accountants themselves.
Did you summon the register and all before the labor court? Did you summon the register?
There are a number of petitions filed with the in some petitions, they have stated the same chartered accountant cases only, the same person. They it is stated they are not, there is no relationship between the employer and employee. In these two cases only, they have done it, I requested the department to get how many cases are filed and what are the orders, in WP 1 is pending before my lords, okay, WP 44798 of 2012. In that, the labor court has presented their claim, stating that there is no employer and employee relationship. That person was also working with us based on the agreement between.
No, how is this respondent number 2 a necessary party in this petition when you have not even taken such a contention before the labor court? What was your
contention before the labor court?
What was your objections before the labor court? And how is a necessary party? You have to only prove that.
He is a necessary party based on that, there was a contract between the petitioner and.
In all the contract matters, will you always include the contractor? Now in this, where is your statement of objections?
Statement of objections is in the.
What is your objection?
It should be based at the.
Annexure B.
Submitted in the second time yearly. Interested the ledger maintenance to the contractor for the office work purely on a temporary arrangement. Based on this contract addition.
It is only the contractor who engages the workers and has entire control over them. Whether the first party is not a workman as defined in section 2, subsection S of this one. Not relevant.
Number 7 million.
They filed their objections to this application. They directly implemented you in the cost title or how was it? How were you implemented?
Not taking this step before the labor court to arrive at the time. In fact, when I was in the cross examination, he admits that it was the first respondent who gave a letter of appointment. He was in the payroll of the first respondent.
Was there any appointment letter produced by them? So the fact that he was a contractor along under you, he was working under you, it means that he was working under you.
He says that he was working on the first respondent.
He may stay, but has he produced any appointment then?
These are the, sorry to intervene, I represent the respondent. These are the chartered accountants. They are made a party, surprisingly, the red petition. They are no way my employer.
Yes. How did you make them as a party if there was no objections raised?
They are assuming the order of the labor court. I am not a party to the proceeding there.
By which order you pleaded this respondent number 2?
There's no order, my lords.
There's no order, my lord. Why does it also? It's against the act, my lord. Then
Yes.
more of the act.
Have you filed objections to this IE for deletion? You file objections, will pass order. He is not a necessary party in this. You file ob-
I'll make it. Again, Hare Krishna will the pay. After the pass away, they have only check on. I don't have any papers also. But I requested them to get all the documents and whatever the restrictions are pending.
That was a submission made on the last occasion.
I have received.
You have to-
restrictions. That's what the reason.
So this
Take with the officials and I'll.
On the last occasion also, the submission was made. At your request, this matter was restricted. Is
The
it
thing
not?
is that we don't know if they got the restriction and the HS.
So how is respondent number 2 a necessary party in the writ petition when he is not a party before the labor court?
Yes,
That's the simple question.
yes.
And you have to prove whether there was a relationship between as of an employer and
That
an
was the
employee.
reason, you know.
But that doesn't mean that you can impede anybody on the earth and say that he was a contractor if you have not raised at a first.
That was the reason I'm making the submission. 10 days time, maybe. I'll ask you the matter.
We'll give you 1 week time, you file your objections and we will pass orders on that. Serve the diet.
In the meantime, 17B order has not been complied with since 2018.
File execution or you take contempt against them. Let them, then only they will proceed with this matter. Yes. I3 of 2017 is filed by the respondent number 2 seeking deletion of respondent number 2 from the present proceedings on the ground that the respondent number 2 was not a party before the labor court. Petitioner counsel 6 times to file objections to I3 of 2017. At request, a week's time is granted. Place this matter on. 18. I think it's 5,000. Have you deposited 5,000? Will deposit. How is that respondent is filing for what is the ground made out now for producing this document? Let him pay the cost. Petitioner to pay the cost as ordered by this court on 3/7/2024 during the course of the day. During the course of the day and file an acknowledgement to that effect. I1 of 2024 for the production of additional. To be heard along with the main petition. This matter for in preliminary hearing P group on date 24. Yes, Mr. Somsekhar.
Milords, in this case, I have made an application for a direction to the respondent workman and to the branch manager, State Bank of India, to produce the extract of savings bank account number so and so of the respondent. Milord, it matter arises this way, Milord. He suffered with an injury which was not connected with employment. Then he raised a dispute saying he has been wrongfully terminated. So far, we have paid over 13 lakhs of rupees only by way of 17B wages. Now more than 13 lakhs by way of 17B wages, and yet I am continuing to pay. But I know for definite he is working in a one message Storage Technologies and Automation Private Limited, and is drawing 20,000 rupees salary. In addition, he has number of other income that he gets. Now, for no fault of mine, for an accident he suffered outside, I am made to pay so much. Now he says, no, you can't make a roving inquiry about my assets, about my various. That is what he says in his objection statement.
My lord, I have
Now, my
not yet filed
submission
my
is-
objections to this IA. I was going to request some time, my lord, 10 days time to file my objections to this IA.
Filed
I've
by
filed-
you to IA number 1 of 2024.
That was IA 1, my lord. Now they have filed a second IA, my lord. The IA to amendment was allowed. That was the objections to IA for amendment. Now they have filed IA for direction. I'll file my objections to this IA, my lord. If it may be on next Thursday or Friday, my lord.
Yes. Yes, senior counsel, let she file her objections to this.
Very well, Miller.
Please, my lord. Obliged.
Avani Kuchokashi, learned counsel for the respondent, seeks time to file objections to IA2 of 2024, which is 2 weeks' time is granted. List this matter on 25th.
Deeply obliged.
25th.
Obliged, my lord.
What is this dismissal of petition? Who has filed this?
My lords, I appear for the respondent.
What is this? On what ground they are seeking for dismissal of this?
My lords, I have filed this IA, my lords.
International workers. No, against what order you are before this court? What was the order?
No, the order commences at page number 14.
40?
14 it commences, my lords, which is Annexure A. Your lordships may kindly come to the paragraph 12 at page number 23. Here, my lords, it is also noticed that the individual Korean employees presently available in India have filed their affidavit indicating that they are covered under the social security scheme of their country and would like to continue there. Their wages are beyond the coverage and scope of EPF Act as specified in para 26(6) of the scheme. In respect of remaining Korean employees who left India after their short-term deputation is over, Mr. So-and-so, Vice President of so-and-so Korea, has also filed his affidavit stating that the Korean employees were covered under the national pension scheme at Korea. Notwithstanding the above said, the determination of dues made by the commissioner is hit by duplicity of special security coverage and was also hit by bilateral agreement, besides being clearly in contravention of provisions of para 26(6) of the EPF scheme. And amount computed is beyond the prescribed limit of coverage prevalent at that time. The appellant submitted that EPF is a beneficial legislation for the benefit of individual identified workmen. In the instant case, the commissioner has identified the Korean professionals employees working in the UJV without taking into consideration of the agreement entered into between two countries, and also ignored the UJV agreement and second agreement entered into between the parties. In view of the above, the appellant cannot be held responsible for the PF liability of Korean employees in accordance with the Indian laws, since such workers were eligible to continue to avail the benefit of PF and pension under their domestic laws, as protected under the bilateral agreement. Accordingly, the impugned order is set aside and the appeal is allowed.
Now,
This is the order.
this international workers and those who are having the social security scheme of their country, they are protected and they are not liable to pay this EPF.
Please.
Then where's your senior? And what is the submission you made now? What is the partial? Then why are you making a partial submission before the court? Is it proper on your part to make a partial submission? So when you don't have proper instructions, please don't make submission to the court. That was not your submission. You said partial information. You went on the merits of the case. What is that partial information? For that, your senior has to come to give you the remaining partial information. Then. See, they are not, they are excluded under the EPF scheme. Pass over, let your senior.
Grateful.
Who is impleading?
Because the management of the society has been taken over by the government and the authority has been appointed.
The notice has to go to them.
Yes, ma'am.
Issue emergent notice on I number 2 of 2024 to the proposed respondent number 2. Who has filed this direction? What is the direction? 17B. Reinstatement. Refund ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ. ಹ್ಮ್.
Effective from first of all, it has to be adopted by the state. And usually not all circulars are adopted by the
Yes, sir.
before it getting put up by the 10 days. By which time it's submitted.
Now they have to adapt your circular, right? Then why don't they adapt it immediately?
Because they're not aware of it. Because it's only issued periodically. By the time the case to like it was on 20. Effective from first of all. And inform.
So we will record your submission that
But I think it's a just take it.
to give that circular. That circular has to be adapted by this being.
I asked the Lord, just now I asked them. And the proceedings perspective. They will close it. They find it and take an order from the.
So in identical trainee matters, the KSRTC has already issued a circular. So we will say that PMTC also has to adapt it. Then they will not do it in a hurry. They will never do it.
I am following it up because I have taken it. But in 10 days time, I think without they will do it 1 week. By way of abundant caution, I'm asking to 10 days.
We will list this matter on 23rd. By then we should get any.
Yes.
Objections now. Yes, yes. Sir. No, let them put anything. Petitioner counsel seeks time to file objections to I-1 of 2025. At the request, 2 weeks time is granted. List this matter on 24th. 24th. Similar. So I-1 of 2024 would not, dispose, we have to dispose it of.
How they find an application? Why they did not file all these days? Because the many cases pending. Now my lord, the cases, the applications are filed. When this dropped up, my lord, when they issued, we had to verify this dropped up, the matter was being covered. All these applications are filed. The month of April 3.
Reinstatement was done.
All those training employees.
When you reinstatement agniva, when were you?
Again, what involved, 8% to the training period. Either case, after reinstatement. Our reinstatement moves for the Kashaya.
Now he is working with the KSRTC now.
Then after reinstatement, those will be take care of order. Involved may not reinstatement. I just have to file an application and seek for an early order because of spot.
Correct. ಈಗ reinstatement ಆಗಿದೆ. Now according to you, they are paying how much now? 10,000. Now as per the circular now issued, they are paying 14,000. 14,000 should be from the date of, from August. ಅಲ್ಲ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದವಾಗ 22/3/2024 in the month of March 2020. And when was the order passed? 1988.
It is from first of August.
From August. Where is the circular? We'll pass over them. Get that. If you will allow their application, in part holding that they are entitled.
By recording my statement that terms of holiday in 1980, but I lost
Yep.
the memo. But you lost my IP, there's file it along with the and file to.
Where is that copy? You have the copy of it?
This.
I-1 of 2024 is filed for direction. Yes, correct. Direction. $14,000 from 1/8/20.
1/8/2022. By an audit.
I-1 of 2024 is filed by the respondent workman seeking direction to the petitioner management to pay current par minimum salary attached to the post of the driver from the date of reinstatement pursuant to the interim order passed by this court on to the interim order passed by this court on 14/11/2018. A learned counsel appearing for the petitioner corporation submits that the corporation by wide circular dated 19/8/2024 has the circular number 1725 of 2024 has indicated that the trainee workers whose matters are pending before the court, are entitled for LRGO training, not minimum wages. Whether a trainee is a, it is not a. No, in this.
Current wages. But when they were removed from the case the Lord has to be taken because in this case, one of the cases was not allowed for was not even getting what he was paid. Allow ಆಗಿದೆ and I submitted to the court even if this petition is allowed, he won't get what he's paid. By way of some interim measure may not pay.
It is only an interim measure. This would not be a.
Not a minimum wage.
Indicated that the trainee workers whose matters are pending before this.
Trainee workers are entitled for 14,000. This is interim arrangement. Otherwise, they will not even get that amount. So it is better.
But whatever that is there, my lord, I cannot submit much more than that. Whatever is the circular, my lord, the decision is taken. My lord, that is what is
Total 14,000 trainee workers are entered. Circular
Hearing for the petitioner corporation submits that that white circular, the corporation has decided to pay rupees 14,000 per month with effect from 1st August 2024 as an interim measure. But we will say, this quote will say 14,000 per month. The said submission is recorded. In light of the submission, the application filed by the respondent workman is disposed of, directing the corporation to pay 14,000 per month from August 2024 as an interim measure pending consideration of this rectification.
don't agree for this.
What about the earlier from August? No, they have to sustain.
The very fact that they required all this because they didn't come because the matter was covered by the decision of the division bench. So they didn't want this to be disposed of and they worked on whatever the amount that was paid. Now in view of the order that is passed, that one also the matter is pending before the Chief Justice.
Full bench.
Raja bench. The applications are brought up after the lapse of nearly 7 years they work there. Therefore, we don't have two submissions. So they struggle. They don't agree for this. And within
17B wages would be lesser than the amount which you have agreed.
Yes. That's one. But I don't know. But one thing is.
So you pay 14,000.
They can be a chance not for application. You not displace any work without work. Some punishment may not get into the corporation. Yes. And they will also get the arrears. What they don't understand is not getting not with past the period for which they have worked. We never deny the arrears, whatever the order that is passed with this order. Would come the date of being paid. Till may not the final order is passed. Because they have discharged their duty, never deny. Even in the settlement cases, ensure that they were paid arrears.
Yes, Mr. Ajesh Kumar. Out of the instructions now.
We can go ahead and make the payment.
Then make the payment.
2 weeks, for 2 weeks and
You make the payment within 2 weeks. How much is that? What is that INR for? So we'll grant, they'll pay it within 2 weeks. We'll take an undertaking. This quote on 27/8/2024. Attend the matter for want of attend the matter at the request of the petitioner for want of instructions from the insolvency resolution professional. The learned counsel for the petitioner submits that they have received instructions from the insolvency resolution professional, indicating that they have to. You're filing this memo and instructions available, and the memo is filed to the effect along with the copy of the email addressed to the petitioner on 9/9/2026. The said memo is taken on record. Then it counsel for the petitioner submits that some time would be granted for the petitioner to pay the arrears of 17B wages pending from February 2024 to July 2024. Till date. At request, 2 weeks time is granted for the petitioner to pay the arrears of 17B wages from February 2024 up to date and continue to pay 17B wages pending consideration of this petition. The interim order granted by this court is extended subject to compliance of the 17B wages within 2 weeks. 2 weeks admin 1 day. 24. Same, ma? 2023rd actually. And AB Srinivas? Who is not well? AB Srinivas is not well. Who's the IA? He has to make some arrangement. On the last occasion also, this was the submission made. In argue matter. What is the order under challenge now? The focus notice has been challenged. What has been challenged now before this court? What is challenged, Mr. Jagpati? Annexure E and Annexure G.
Yes, sir. You have made the rule and the order passed.
They are the competent authority according. That is the main ground which has been urged before this court. So I think that is all settled. There, I think one of the orders is there, right? They're in. What is that rules? You produced along with your objections? Yes. 23? Yes. It says under this regulation, an authority to inquire into the truth thereof. So who is the authority which they have appointed? No, their grievance is the entrustment to the lokaयुक्त was not stopped. Yes. PCA. So are they covered by the KCACS and PCA rules or not? So now their rules is there. So it is the authority, the regulations prescribe an authority under them, not the loci. So they are justified in saying that the interest, but it is only the authority they say. Look at that. Authority, an authority, or appoint under this regulation an authority to inquire into. Where is that authority mentioned in this? So authority would be within within their corporation, right? Have you produced along with this policy? So authority means any authority. No, that copy is not available. Yes. Tenor A of the case pay. No. Seven. Ah. Ah. What did the division bench hold? Just a moment. No, first, what is your contention now? What are the grounds now you have urged the first of all? Yes. Lokaikta has no? Just a minute. EMTC. Yes. The regulations mention that they can appoint any authority. Twenty-three. Yes. Which paragraph you're reading? Paragraph? Yes, yes.
Taxation, cultural, identity, of so there is no interest rate of the capital of cases or the law adopted by the CNA regulation and
Yes. Yes. Now they say that it has not been adapted.
So,
No, but this division bench, right, when they do not adapt the TCA rules. Yes, now in as per the regulation also, they say under the regulation and authority and competent authority has been mentioned in your local style. But then these the petitioners are not the government servants, they are the public servants. Yes.
and also at that stage, so not there are.
Which judgment you are reading now? Ah, yes. Yes.
State government cannot serve jurisdiction. Right.
In these cases, state government, who are competent authority under the government, was required to prove of their reality.
Yes.
Passed by the managing director. Ultimately, he is the
He's the competent authority.
competent authority. This order is not under the 14A, but neither the foreign corporation is 14A is adopted. Nor will not get that this order is not under 16. This order is not under.
Then how is this entrustment justified? 23(2), but an authority, when an authority would be under them, not the authority of.
Where
Where is that? Where is that?
they are also not an authority.
So authority, where do you define authority? Where is the authority being defined?
But in this regulation,
Then how do you say that who is the authority?
the authority has to be other than what it is.
Then where do you get it? Where do you get it? See, there is to be some definition for the authority which the regulation prescribes. In the absence of any definition prescribed in the regulation for the word authority, who would be the authority? Can it be directly a Lokayukta? Is it not?
Has to be not a
See, we need something for that, for the word authority. Competent authority. No, because the competent authority has been defined. It's been defined under the, everywhere it has been defined. Competent authority is the one who is competent. And then it has been defined under the Lokayukta Act as well. It has been defined. But for the authority under this regulations, for this, for the respondents herein. Yes. It can be authority or any other authority. Any other authority, then you would be included. But how is an authority mentioned in the regulations to be defined as any other authority? 20. Corporation or any other authority empowered. So you have to now elaborate saying that this any other authority means the local, or rather the corporation has to serve them. In the absence of this adoption of Rule 14, the question here is there is no adoption by them. So they have mentioned in their regulation that any authority, and as per rule regulation 20. Article 12, what does it say? Third in part. This is the matter for further hearing. Day after tomorrow. Day after tomorrow. Tuesday. Tuesday. Yes. ಆಗ್ಲಿಲ್ಲ ಅದರಲ್ಲಿ. Case of respondent consequences matter next week. Hiremed Praveen Kumar Appaya. Support. Is this matter after 2 weeks at request of the petitioner. You mentioned that there is a settlement. Yes, we should have just mentioned in the first agreement. It's been settled. Respondent is present. Ibridara. Petitioner. Advocate. Respondent yaro. Workers. Two workers. They have signed the joint memo. Trade union alva, the president. Two workers. How many workers? Baswaraju and Where do you get it? In the before the labor court order? Reference, Joint memo, sign, joint, impugned order early. Sri Hanmant Raju. One, and one more. Baswaraju. Baswaraju P and Sri Hanmant Raju. They had sought for reference, no?
They were not paid their wages, not possible for other workers.
They are paying them.
They are paid them.
Baswaraju and Hanmant Raju, who the union, registered union, raised dispute before the labor commissioner, assistant labor commissioner. And the labor commissioner, by order of reference dated 7/1/2022, referred the matter to the Industrial Tribunal in ID number 14 of 2020. Go to reference, order of reference, 7/1 and 4/2/2022. Assailing the order of reference made by the first respondent. The idea assailing the order of reference dated 4/2/2022 made by the first respondent, the petitioner management is before this court. Both the counsel on both sides submit that the petitioner and respondent number 2 have amicably settled the dispute and filed joint memo of settlement signed by the authorized signatory of the petitioner management and the workers of respondent number 2 union, namely Baswaraju and Hanmant Raju. The terms of settlement reads as under para number 1.5 to 1.4. The terms of settlement forms part and parcel of this order. Yes, in terms of the settlement, the petitioner through his signatory, authorized signatory, is handing over DD of number mentioned madlilva. You have to give a Xerox copy of. Yes. DD number 011899 in the name of Baswaraju for a sum of rupees 3,56,510. And another DD bearing number 011898 drawn in the name of Hanmanta Raju H for rupees 3,42,716. Give a Xerox and incorporate it in the courier office. The DD numbers mentioned above with the amount enumerated mentioned above has been handed over to the to Baswaraju and Hanumant Raju, who are present before the court. Courier. You should give a photocopy. You file this photocopy along with this memo. They are taken. In light of the settlement arrived between the parties, the impugned order passed by the impugned order of reference and the notice dated order of reference dated 4/2/2022 and notice dated 7/2/2022 are hereby quashed. ಅಲ್ಲ ಅದು ಬರೋ ರೆಫರೆನ್ಸ್ ಇರಲ್ಲ ಮತ್ತೆ fact and would not survive for consideration. You have to go and find a memo. The petitioner, the respondents. What are did not survive for consideration. Does not survive for consideration. Does not survive for consideration. And the proceedings initiated after the pursuant to the reference needs to be, which is that is AID number 14 of 2022, needs to be withdrawn by the needs to be closed but withdrawn. Needs then reference illandre IID number what is reference is not surviving, then they have to file a memo to that. And
in terms of the settlement, it is clashed. Not with the
yes. In terms of the settlement, ultimately you want to again raise a reference. No. Then reference and pursuant proceedings in AID number 14 of 2022 stands closed. And closed. You file that memo before the we will see, Mr. Council. Let us not hurry into such matters. Yes. Dictation. Yes, Mr. Kuttappa, what happened?
ಇಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ಲ ಇದರಲ್ಲಿ because the gap is so wide. So we'll as well take an order from the hands of this honorable court.
We had already listed the matter for dictation. Now
Yeah.
we have to again do that exercise. Is it not, Mr. Kuttappa?
Allah,
What
we
was
tried our best.
33.
Milord, they are all transferred according to the conditions contained in the appointment order. They refuse to go on transfer. One person, Venkatesh Achar, has reported and working in transfer place. Others have also accepted transfer and gone. ಇವರು ಮಾತ್ರ ಹೋಗಿಲ್ಲ 3 ಜನ.
You did not go
ನಾಗರಾಜ,
to the place
ಉಮೇಶ್,
of
ಯೋಗಾನಂದ.
transfer. You didn't go to the place of transfer.
No.
No, we have argued at length.
Yes, we will pass orders. Both the councils submit that there is no possibility of settlement. This is the matter for dictation on 17.
Much obliged.
That's all.
Yes, Mr. Murlidhar Peshwa. This matter. Yes. You did not hear, the serial number was called. How can you only hear his name? It's serial number 24. So naturally you will be hearing his name. Is it not? How can you make such a submission, madam? Yes. Serial number 24. Do you have the cost list? Serial number 24 is Murlidhar Peshwa. Do you appear for Murlidhar Peshwa? Then counsel submits that petitioner counsel L. Murlidhar Peshwa has undergone surgery and has been admitted in hospital at Mysore. Noting the submission made by the counsel. This matter after 2 weeks. Date 41, the 2 weeks. Yes.
First time. Then since it was done for some time, not yet decided to consider it as part done. Thereafter, unfortunately, it was not at all listed. Now I am ready, madam.
What is this matter about 33 to
Matter where, my lord, the worker has submitted a false caste certificate. The DCVC, the District Caste Verification Committee, held proceedings. He also participated in the proceedings. Held that his caste certificate is fabricated and he does not belong to scheduled tribe. The job which he was secured was reserved for scheduled tribe. He declared at the time of appointment as Nayaka. The DCVC declared him as not coming under the category of Nayaka, belonging to Nayaka. He is belonging to another caste which does not come under the category of scheduled tribe. And they recommended the BEMEL that he should be sent out.
What was the application which you filed? What was the dispute pending?
33 to be.
No, what was any dispute pending between the parties?
The BEMEL filed a 33 to be application seeking for approval of the action of dismissal. Since the ID was pending before, Mysore Industrial
Which was that ID pending?
Mysore Industrial Tribunal, ID was pending. So we filed 33 to be. Lordship knows that it is a summary proceeding. There was no domestic inquiry because only based on the DCVC order, we cannot hold inquiry because of the Madhuri Patel's decision. Whatever DCVC thing, we have to follow the order passed by the DCVC. This order of the DCVC has not been questioned till today. That has attained the finality. Now, the tribunal very strangely says it sits over the appeal taken as the DCVC's order in a 33 to be proceeding, holds that it is not a false certificate, it is a wrong caste certificate. This is the very same finding that is given by the Industrial Tribunal, holds that approval cannot be granted.
Yes. Which is the reasoning?
Now, kindly see, my lord, Adla.
What is that you want to say? So let him complete his argument, then you can address your argument.
Now you have to kindly see. Kindly go to Annexure A. This is the appointment order of the respondent who was initially appointed as a technician, fitter mechanic. Annexure A.
Annexure A.
Annexure A, page number 13. Now, the supporting document to show that he belongs to scheduled tribe is an affidavit which was filed by him, which is annexed B, page number 15. I swear that I belong to Nayaka by caste, which is classified as scheduled tribe as per zero of Karnataka. What happens, my lord, in any public sector approach at that point of time, we were not asking the caste certificate original. We were taking some.
When was his date of appointment?
Date of appointment was that is my lord.
1992.
How? 1st May 1992.
He filed an affidavit saying that
He filed an affidavit that he belonged. Thereafter, he submitted the caste certificate Annexure C after joining the employment.
Annexure C.
Annexure C. Territory Karnataka belongs to Nayaka tribe, which is recognized as scheduled tribe. Now, the procedure is wherever such appointments were being done, we were required to refer it to the DCBC as per Justice Kadri Patel's decision. Now, we referred it to the Deputy Commissioner, Chairman, District Caste Verification Committee, Madhya. Kindly go to Annex page number 19, Annexure D. We referred the matter along with another employee, P. Kemparaju, to the DCBC. Both were appointed as senior technicians in different departments. We referred them. Now, the DCBC held proceedings, issued notice. Kindly see one of the sitting that was held by the DCBC, Annexure E, that is the notice issued to workmen also. They held proceedings. Finally, they passed an order. This I think it requires a little bit reading. Kindly go to page number 21. May I read this? Abhyarthi Shankar Nayaka, Ivara, Prathamika Shale, ಒಂದನೇ ತರಗತಿಯ ಶಾಲಾ ದಾಖಲಾತಿ ಜಾತಿ ಕಾಲಂನಲ್ಲಿ ಜಾತಿ ಲಭ್ಯವಿಲ್ಲವೆಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. ಈಗ ಕೆಆರ್ಪೇಟೆ ಇಲ್ಲಿ 4ರಿಂದ 5ನೇ ತರಗತಿ 4ರಿಂದ 5ನೇ ತರಗತಿ ವ್ಯಾಸಂಗ ಮಾಡಿದ್ದು ಶಾಲಾ ದಾಖಲಾತಿ ಜಾತಿ ಕಾಲಂನಲ್ಲಿ ಪರಿವಾರ ಎನ್ನುತ್ತಾರೆ. ಸಹೋದರ ಸೋಣಸೋ ಹಿಂದೂ ಪರಿವಾರ ಎಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. ಸಹೋದರ ಸೋಣಸೋ ಜಾತಿ ಕಾಲಂನಲ್ಲಿ ಹಿಂದೂ ಪರಿವಾರ ಹಿಂದೂ ಪರಿವಾರ ಎಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. ಸಹೋದರಿ ಸೋಣಸೋ ಜಾತಿ ಕಾಲಂನಲ್ಲಿ ನಾಯಕ.
No, this question is not there before this court. The question is
approval would be rejected.
What is the criteria for rejection for grant and approval? So what is
now
that?
why I am reading it? This was the decision rendered by DCBC, which has not been challenged. It has attained the finality.
So the misconduct is from out of employment.
Yes.
That is on seeking for employment. He has given a false certificate.
Based on that, he has passed an order which requires certificate.
There is an order of the disciplinary authority.
Page number 23. We have stated in the communication after full-fledged verification, DCBC page number 4, page number 23.
This is the order of the
Yes.
disciplinary authority.
Yes. Showcase notice. Showcase notice.
And where is the order of the disciplinary authority?
These are the showcase notice issued to him. He has given an explanation, Annexure G. Thereafter, we have issued the notice of removal, that is Annexure H, page number 27.
Yes.
Page number 27. With reference to your explanations, don't answer exactly. There is an intent to confirm the proposed service. Now, since an ID in reference number 1/2007 was pending on the file of Industry Tribunal,
What was the dispute regarding?
Dispute was related to some canteen maintenance, where he was also a party. So we filed approval application, serial application number 1/2009. That went on for adjudication since there was no domestic inquiry issue. On merits, the matter was considered. Kindly go to my Annexure A. Today, the Lord will notice that the Tribunal has virtually sat in an appeal against the order passed by DCBC. Why I say so is kindly go to page number 37. The other things are claim statement and other
37.
Kindly go to page number 37. Reasons. Page number, para number 3. The applicant in the routine procedure sent his caste certificate to so for verification. Then the DCVC as per his report dated 10/2/2009 reported that the respondent does not belong to ST category, Nayaka caste, and he belongs to so category 1. Applicant on the basis of the DCVC report conducted domestic inquiry, so there was no domestic inquiry, proposed the, it was only show cause notice, proposed the punishment of dismissal from service and called the explanation. The respondent given explanation, then the application is on. So now kindly go to, we have cited few decisions, kindly go to page number 39. Yes. Go to that. Para 3, page number 40. So, bearing in mind the above principles and apply to the facts and circumstances of this case, the second party on the basis of the DC report, DCVC report as the respondent at the time of employment, given caste certificate, but only he belongs to Parivara caste. As such, caste verifying committee in its report helped respondent to get the ST reservation benefit given false caste certificate stating that he belongs to Ayaka. Being proved in this regard, no doubt, the respondent has not challenged the said order before the competent authority. This status is so even today. So the same has to be considered as it is. In this case, the applicant alleged misconduct against the respondent as can be seen from Exhibit A15. In this case, the respondent has seriously disputed the same. Therefore, as it is only approval application, this tribunal has got only limited jurisdiction and only consider the said misconduct prima facie, and the tribunal can interfere with the order of dismissal only if the findings are pervert, etc. Next, your lot may kindly go to para 3, that is page number 41. Therefore, if the said misconduct is prima facie considered, it is to be seen whether the respondent is given false caste certificate. In this regard, as per DCVC order, the respondent's school certificate of the court that puts the respondent in the caste column, expanded in the caste column Parivara, you mentioned. Likewise, his brother, but the social welfare officer of the KR on the basis of the spot verification report dated so reported that originally he belongs to Parivara caste. So, from the above materials, in the concerned government department records, his caste is mentioned as Parivara.
This will set aside this order, remand the matter to the.
Not necessary, madam.
No, the reason is, let the labor court also do the entire exercise as to under what circumstances 33 to
No,
be.
submission case. This is an approval application. Even if the approval application is
if it is allowed, that will not be.
Because he has got a remedy. And the idea of my humble submission is prima facie that tribunal number 2, the tribunal refers to a government order, state government order. Now that the Supreme Court has held, in fact, our decision Mysuru, the Supreme Court has held that that particular order is applicable to state government industry. The BEMEL is a central government public sector undertaking. In the similar case of PHEL, where that is also CPSU, the Supreme Court has held it is not, that notification is not applicable to CPSU. In these circumstances, my humble submission is prima facie approval is required to be granted by this honorable court, because the approval will be rejected, as your lordship knows, on certain grounds. This is not a ground on which the tribunal could reject the approval. Literally, the only finding is it is not a false caste, it is a wrong caste. The tribunal has no prima facie, has no jurisdiction. Approval is required to be granted. Now, in support of my case, I have filed few decisions also. In fact, the last occasion I had given with the list. Now I am going to submit one more set of sections. The first decision is, of course, Justice Kumari Madhuri.
That is not relevant.
DCVC
that is not.
Now, insofar as the jurisdiction under 33 to be the
Only
second
33,
decision.
only 33 to be, Cholan roadways.
The decision of Cholan roadways, that is 2005-3 SEC 241.
This is summary proceedings.
Yes, 33 to be okay. Additionally, kindly see method para number 12. Para number 12. The relevant paragraphs are para 12, 13, 18 and 20. Section 33 2B of the ID Act reads as under. It is provided, it is neither in doubt nor in dispute that the jurisdiction of the Industrial Tribunal under 33(2)B is a limited one. The jurisdiction of the Industrial Tribunal under 33(2)B cannot be equated with section 10 of the ID Act. In this case, admittedly, the inquiry has been either other facts particular there. Kindly go to next para, that is para number 13. Para number 18, you'll have to kindly go to para number 18. The jurisdiction of the tribunal, while considering an application for grant of approval, has subsequently been stated by this court in Martin Burn Limited versus R.N. Banerjee. While exercising jurisdiction under 33(2)B of the Act of the tribunal is required to see as to whether a prima facie case has been made out as regards the validity or otherwise of the domestic inquiry held against the delinquent, keeping in view of the fact that if the permission or the approval is granted, the order of discharge or dismissal, which may be passed against the delinquent employee, would be liable to be challenged in the appropriate proceeding before the industrial in terms of provisions of so on. So, now kindly come to paragraph number 20. The tribunal, while exercising its jurisdiction under 33(2)B, was required to bear in mind the aforementioned legal principles. Furthermore, in a case of this nature, the probative value of the evidence showing the extensive damages caused to the entire left side of the bus, the fact that the bus hit the branches of a tamarind tree and when stopped at a distance of so on. So therefrom, even after colliding with another bus coming from the front, deserved serious consideration. They handled the nature of the impact clearly. So this is as far as that particular case is concerned. Next, we will have to be kindly into the decision of PHGL, which I was mentioning, that the state government notification is not applicable. The relevant paragraph is paragraph number 13. What is the impact of taking the persons who does not belong to particular category? It will be clearly explained by the apex court. Para 13.
Page number?
Para 13, 343, page number 343. The principle which seems
Page number 30.
343.
Which judgment you are referring to?
It is additional general manager human resource PHGL. 343. The principle which seems to have been followed by this court is that where a person secures an employment on the basis of the false caste certificate, he cannot be allowed to retain the benefit of the wrong committed by him and his services are liable to be terminated. However, where a person has got admission in a professional course like engineering or MBBS and has...
This is all on merits.
This thing is, the tribunal has referred to VO of the state government.
While considering the application under section 33(2)B,
Yes.
what is the criteria by the labor code to be considered?
That Cholan roadways clearly explains.
Only those criteria.
Yes.
If that has been satisfied, then 33(2)B has to be allowed.
Of course, I have cited a few decisions, of course, relating to 33(2)B only of our own report. That is that the division bench decision in a similar matter. In a similar matter of caste certificate of the Tribunal.
Correct. In that inquiry was conducted.
Inquiry ಮಾಡಿದ್ರಲ್ಲಿ.
Literally inquiry ಮಾಡಿಲ್ಲ. So this is something.
Other required decision. we have no authority to hold an independent inquiry. And there was one more charge coupled with caste certificate application to the Indian. Because of that, we held the inquiry. The only charge is producing a false caste certificate. We did not hold any. And I have referred to one Bhanumurthy decision that is listed at serial number 7 and serial number 8. These are our own high court. The relevant paragraphs also are mentioned in this.
Have you followed the conditions, preconditions that are necessary under the
33 to be compliance, there is no dispute.
There is no dispute.
There is no dispute. We have received the last language, whatever is correct. And we have done it simultaneously on the very same day. All these aspects, the tribunal has not said anything, except saying that there is a wrong caste. When is the operative portion?
Other judgments which we have relied, it's all under section 11A. They are not applicable, but
They have relied upon the other decisions is relating to caste certificate. They're all relating to caste
caste
certificate.
certificate on merits, you will be entitled. On merits, where 33 to B was not the consideration before.
That kind of thing is it's the unreported decision, petition number 1142 of 2010. On topic. There also, the payment filed the approval application. The approval was granted. Against which the worker filed a writ petition. Writ petition has been dismissed. Here, the seriousness of the caste certificate, taking the employment of the caste certificate, has been dealt with by this honorable court. Otherwise, they refer to DHA decision also, where the DO is not applicable to the civil. When you go to the relevant paragraphs are para 12, page number 6, para 13.
This was again an award of the labor court.
The approval application, award, of course, by the labor.
Ultimately, now we have to only
Yes.
see 33 to B. What happens in the event an approval has been granted? It means he would be dismissed from service. And the proceedings, he can initiate proceedings under section 10.
I have referred to writ petition number 41583 of 2012, dated 6th September 2018. Yeah. Serial number 7.
Serial number 7. 41583 of 2000.
So, very similar matter. There also, the Bangalore Industrial Tribunal, against which I filed a writ petition. There, of course, the tribunal rejected the approval on the ground that some the payment was not sufficient, and secondly, because of the caste certificate. This court had an occasion to go into the details. The court, after explaining, after taking into consideration of the purview of 33(2)(b, has given a finding. Kindly go to para 12. As per the submissions made by the petitioner, the respondent does not belong to the community. If a person produces a false caste certificate or suppresses any fact and obtains employment as well as benefit, then compliance of 33(2)(b shall not be insisted upon the employer, since it is a misconduct and misrepresentation committed by the respondent. Under this circumstance, application under 33(2)(b is maintainable. It ought to have been accepted by the tribunal just because caste certificate of family members showing their caste as Nayaka that cannot be taken to uphold the contention of the respondent. Moreover, in the instant case, father of the respondent migrated from Tamil Nadu, of course, this is relating to that particular record. It is to be noted that caste certificate issued by one state cannot be taken as a proof of caste in other state. Domestic inquiry is held to be fair and proper, and the competent authority has found that respondent belongs to owner which is not falling under scheduled right. The tribunal has proceeded on the basis that family members of caste certificate show their caste as Nayaka. As already stated, those caste certificates cannot be taken unless they are certified by the verifying authority. In the circumstance of the view that impugned order is liable to be passed, the application filed by the petition for approval of termination needs to be accepted. In that case, the approval was granted by this honorable court. Here also, this is one of the contention was his sister has declared as belonging to scheduled tribe. That cannot be accepted. So this decision, this honorable court proceeded to grant the approval. And my humble son, I have produced one HCI decision. The last one in the list, serial number 9, in writ appeal number 3666 of 2016. Here also, a very similar fact. The caste verification committee was also made a party. So the court has gone into the details of the powers of the caste verification, and by relying upon a decision of the Food Corporation of India, this honorable court by the division bench has held that
Again, this is on
merits.
merit. Yes.
I only said it. Looking into the facts and supporting this fact. Number one, the approval application has been filed by the company with all necessary formalities, and it is in full compliance with the provisions of 33(2)(b). The tribunal at the most could have seen whether inquiry has been conducted. If not, why inquiry is not conducted. Whether DCVC order is being questioned by the opposite party. If so, what is the outcome? Number three, the tribunal ought to have seen whether the punishment is proportionate or not to that extent. So nothing of this sort has been done by the tribunal.
Perversity, victimization, unfair labor
perversity when report.
there is no perversity here.
It is in our favor. Only on the point that
Victimization and whether the
victimization on the point that his caste certificate can be accepted. Virtually what the tribunal says is not a false caste certificate, it is a wrong caste certificate. You accept that. Merely because he has filed present. This finding, my humble submission, is a perverse finding. Because the tribunal had no authority under 33(2)(b). So in this my humble submission, rectification mechanism, approval mechanism.
And they were given the benefits of the government order created by court.
yes.
And saying that I am a Karnataka. Very court has caused the first order right to the night of the that because the terms Palpala are synonymous in my home. I have not submitted a wrong answer. And I have been discriminated against. As the law comes to
Which is the judgment you are relying? Have you produced along with your This furnish the copy to the court also. ಕೊಟ್ಟಿದ್ದಾರಾ? Yeah. Yeah. So you have been reinstated now?
Following that, the state government of that the Karnataka gave the notification of Karnataka gave it second of July 2020. Stated that so stated that entry of the 13 days. The sentence is the schedule rights stated Karnataka. They entry 13 days for the word Nayaka and the word happened substituted with Parivar and Karnataka.
So he was belonging to?
He belongs to Nayaka, my lord. The district caste rectification committee did not consider that. I think because clearly shows the Shankara Nayaka. They did not consider this document.
But that order has not been challenged by you. DCVC has rejected your caste certificate, holding that you do not belong to Nayaka community. Did the DCVC say that you belong to Parivara community? What is the order passed by the DCVC? No, what is that order passed by the DCVC? What is the order passed by the
Parivara.
Parivara. So if it has been held to be Parivara, now in light of the judgment of the apex court in the case of Jayannas, then it becomes Parivara and Naika would be synonymous.
For that, we wrote a letter. We wrote a letter to the Union of India. Kindly go to Annexurium. Kindly go to Annexurium. We have taken clarification of the national commission for Procedural Caste and breaks. So, kindly see. Annexurium, page number 61. This was a part of the tribunal records. With reference to subject and reference cited, it is to be stated that this office has forwarded a copy of your letter and reference to clarification to the Directorate of Tribal Welfare, who have clarified that the subcaste Nayaka does not figure in the list of SCs and STs in the state, nor it can be treated in par with Nayaka, which figures in ST. In view of this, it is informed to take suitable action as deemed taken as an employee. Action taken in this regard.
And what happens to the full bench decision in Jayanna's case, wherein it said?
But it is not in the 30. But all, if he has questioned this DCVC order, and if he had.
That is one thing. Questioning of the order of DCVC is one thing.
Please.
Having said that he belongs to Parivara community. Parivara
particular view, that is what I was saying upon. That particular view is not applicable to BML in view of the BHA decision of the apex court. Similar thing was taken up in Kerala also, saying that there is a view of Kerala government and it is applicable.
This is not government order. This is an order of the court. It says this Parivara and Naika are to be taken as synonymous, and they both belong to one.
That benefit is not. He cannot get that benefit since he is an employee of BML. That is applicable so far as state government concerns are concerned. That is what is clarified by the apex court in BHA list.
Is that decision?
That decision. 3. Serial number 3.
Yes.
Paragraph number 13. It says notification orders issued by the state government has no bearing on central government public sector undertaking. Paragraph number 13.
Yes.
1-3.
You are reading this order, right? Of 2007. General Manager, Human Resource, Bharti Heavy Electrical.
The additional general manager, human resource, Bharat Heavy Electrical.
You read that,
Yes.
come to the down portion of it, here again, move hard and fast rule.
Third portion. I have read paragraph number 13 and 14. Kindly go to para 16. Para 16.
Yes.
Learned counsel for the respondent also sought to take some benefit of a certain government order dated so much issued by the state of Maharashtra, wherein some reservation in services provided to members of the private. In our opinion, the respondent can get no benefit from the same as he is not an employee of government of Maharashtra, but is an employee of public sector undertaking of the central government, and he secured the appointment long before 31 by 1982. For the reason discussed above, the judgment of the order of the High Court, which is under challenge. So same way, state government also passed an order saying that this particular community is on par with the other community and they should be considered. If not, they should be considered as general category. That is what is being referred in the tribunal's order also. So my specific reply to that is that EO is not going to benefit the respondent since he is an employee of central public sector undertaking for which the EO of state government is not.
That's
Exhibited as A25 and tribunal not given a finding on that.
why we said remand the matter, we'll remand the matter to the. That is necessary.
Quarter zoning. I think he must have attained a superannuation. Now my only submission is, if at all he is entailed for him, he has got a remedy here. And it is not a full stop for employee worker. It is only a summary procedure, 33 pages. And in the similar circumstance, same thing was considered by this honorable Justice Narayana, the decision which I referred. As categorically said, approval has to be granted.
Please for dictation day after tomorrow. Third and fourth. Dictation day after tomorrow. Where is madam? Madam Purnima Hatti.
Ma'am, my lords, I appear for the petitioner in this case. My
Yes,
lords, we
madam.
have no objection to the passover.
Password.
Much obliged.
Why two petitions?
Other one was filed in 2022. First one filed in 2020.
What is the order?
Order challenge is NPSC, where the petitioners are working as daily wage employees for the responding department. There was an white government notification, the Karnataka Daily Wages Employees Welfare Act 2001. The petitioners were allowed to get certain benefits under the act. The year 2013. The Lordship may kindly see the statement of objections filed by the respondents.
What is your claim first?
My grievance is that the date of birth, which appears in the service record, had to be rectified, which are not done. They have wrongly published it as 1960 and 64. When is the petition?
When was it published?
It was published in the year 2014. While annexure, Lordship is R4.
Yes.
The petition number 1 finds a place at page number 17. In page number 17. Petitioner number 2 is at in page number 18.
You furnished the date of birth at the time of joining.
Yes.
And now you want to
I
say,
gave a representation to rectify.
when did you give a representation?
I gave a representation after the act came into force.
What was that?
There was an opportunity given to rectify the name or any discrepancies with regard to date of birth, anything. I gave a representation to respondent number 2. But unfortunately, that representation, best known reasons to the respondent 2, it was not forwarded to respondent number 1. Only when the notification by annexure R4 was passed, I gave a representation. The Lordship may kindly see annexure R5, R6 and R7. These are the documents wherein they say, the respondent says that the petitioners have attested their communications and their agreed. Those documents are prepared.
What is the official gazette 5/3/2014? What is that?
That is.
What is that official notification?
That was the Karnataka Daily Wage Employees Welfare Act, wherein certain persons working under the government department, they were given certain benefits. So that respondent government directed all the departments to send their names so that they can scrutinize and say whether these persons are eligible for those benefits or not. And also they asked them to get the names for any rectifications that are there in the service records to be
Where is that notification?
not produce that notification. Grievance is that my date of birth has been wrongly mentioned in the service records. Lordship may kindly see annexure R4 what they have given. That was published in the notice board. Right after
No, that is on the basis of your application at the time of.
Right.
Now you cannot say that. Now
Right after the notification was issued. Right after the notification was issued of the notice board, I made a representation. Because the Welfare Act enabled me to give representation if there is any discrepancies or mistake to get it rectified. We have given representation and given the representation to respondent number 2. But for the best known reasons, we are not forwarding to respondent number 1. In the year 2015, respondent number 2 came up.
The notification was published in the year 2015.
2005/3/2014.
Then it was published on 7/5/2015. Then afterwards, you did not raise an objection to that publication.
We raised an objection.
Where is that objection? Where did you raise an objection?
To respondent number 1.
When was it?
After the notification.
When published? When was it published?
Notification was published on 5/3/2014.
Then it was published in the Gazette on 7/5/2015. After that, when did you give a representation?
No, madam.
Where is that record?
I will come to that point. Because the representation what we given, we do not have a copy. The petitioners are running. They say all the papers were gutted in the body. All the papers were gutted in the
After 90, when was your appointment? When was your appointment?
1985, 86, 87. I have the
After 85, when the government of Karnataka formulated that act 2007, you made an application according to you. But where is that application? You should have that copy of it. If you have not filed it, they would not have the copy of it.
R7, R8, they themselves have created new documents regarding the biodata, saying that all the
both are the petitioners, both are the same petitioners.
Page number 24 of the respondent.
They had already heard this matter.
They have created a new document. Then they have again, by mistakenly, they have given that my date of birth is so and so. That these documents are prepared in the year 2015 and
petitioners who
So
were
when they had
working
more
as
than one,
daily
how-
wages. The,
One submission allowed. With regard to the second matter, I have a copy of the representation, when he gave the representation.
when did he give a
He's given a representation on 23/2014.
23, 2000?
2014. Well within 15 days time.
What does section 5, subclause 2 of the
15 days time.
then
It was published on 5/3.
for the, of the Act for the Karnataka State Servants Determination of Age Act 1974. You're claiming not 1 or 2 months, you're claiming 3 years, 4 years.
So the date of birth states so. I've given the representation.
That should have been done immediately when you know, no, even if the act was not there, when you join the services, you give up date of birth. Afterwards, you realize that this is no, this is not
I
a
have
date
a
of
copy
birth.
of that also. Second case, the petitioner has given an affidavit in the year 1989 stating that his date of birth is so and so, but they have never rectified it in the service records. This he gave a representation under the act came into
Oh,
year
yeah,
2014. They have forwarded only to year 2019, and then the respondent also said that it is beyond time limit. It can apply that it is beyond time, and after 5 years we cannot do anything about it. But it is without the mistake of the petitioner, because they given the representation well in time. They have not forwarded to the respondent number 1. They forwarded to only the year 2019. Then it's wide annexure. The respondent number 1 passes an order that you change the representation after 5 years of the act coming into force. So nothing can be done. Annexure C followed by that. The second respondent says the respondent number 1 has stated so we cannot do anything about it. And they have listed the names of the petitioner due for retirement. Fortunately, only the petitioner in the second matter please got the representation. The first matter the petitioner that unable taken in there. They keep it with us. They keep a copy of the representation. The copy given by the petitioner in the connected matter. Then it is already his own affidavit in the year 1989 itself, stating that my name, date of birth has been wrongly mentioned in the certain record. Then he gave the representation in the year 2014.
What does section 5 of the Karnataka State Servants and Determination of Act 1974 indicate? Yeah. Within how much period they have to say? From there you go. See, there is a procedure. You give a date of birth. You take acceptance of your service. That is accepted by the employer. After so many years, after working in the institution for so many years, you come and say, no, this is not my date of birth, but my date of birth has to be so and so. That has to be done within 3 years. Come to clause, up to section. When was his appointment? When was it? Yes, when was his appointment? Twenty?
He swore to an affidavit on 3/8/1989. That's well within 3 years.
Clauses within application is within. is the order passed by the respondent number 1?
Someone saying that it is not within time and you have given a representation after 5 years.
So this representation of this has to be considered because it is in the year 1989.
I have a copy of the affidavit sworn. It says 3/8/1989.
Copy of the application or what is that?
Affidavit. What is one? And he's given an application on in 2014 also after the amendment.
Affidavit, what is that affidavit, yes, sir?
Affidavit is on that my date of birth is 1966, not 1961. The service record is shown as 1966.
That is an affidavit which he gives along with the service conditions which is there with him. It is not an application for them to correct the date of birth. Is it an application of yours to correct the date of birth?
I do not have the application, but I have the affidavit.
So that is not available. See, there is a procedure.
So they may be having the records of the application. These are individual employees and they are uneducated. I do not think they would be keeping all the documents. Fortunately, only this petitioner in the connected matter has kept a few documents.
That is the affidavit which he sworn to at the time of employment. That is not a representation for any correction. Does he give any representation for consideration?
But this given the representation in the year 2014. I have a copy of that.
2014.
After the amendment came into force, the government itself notified that those who have to get certain.
Where is that notification?
2 days I will get the
So you were aware about this notification. Where is the notification, madam? Madam, do you have the notification?
May kindly turn to page number 3 of their statement of objections in repention number 1973, where in this day, it submitted that in pursuance of the said act, the first respondent had issued direction to the second respondent to forward the particulars of all the daily employees, including the petitioner who are working in the office, such as date of birth, date of entry in the service, and daily employees category, the qualifications, etc.
Petitioners are the daily wage workers working in the Department of Horticulture. And their date of appointment is prior to both the petitions prior to, no? Prior to 1980. The petitioner contends that
After 1980.
prior to 1980 and in your writ petition. Prior or after a difference in Mr. Counsel. There is much difference between prior. Where are the appointment orders at least?
Want to get the details with their objection. Page number 17 is with regard to petitioner number 1.
In which petition?
In petition number 1973 of 2020.
So all this pertains to the very petition, sir.
The fourth column is with regard to date of appointment.
No, third paragraph pertains to the appointment.
Details.
That is the petitioner number 1.
1/2/1985.
Separate order has to be passed in both the petitions. Separate order has to be passed in both the petitions. No, because their date of appointments are.
Date of appointment is different. Date of birth.
The petitioners in WP 1973 of 2020 are seeking for following prayers. Okay. The petitioner in WP 3344 of 2024 are seeking for the following. The grievance of the petitioners claim. The petitioners contend that they joined the department horticulture as daily wage employees on 1/2/1985, 1/5/1985, 1/7/1986, and 1/10/1986, respectively. The state government of Karnataka enacted the Karnataka Daily Wage Employee Welfare Act 2011 and wide notification dated 15/2/2013 to protect the services of the daily wage employees in order to extend certain benefits to them. And in pursuance of this act, the first respondent has issued a direction to the second respondent to forward the particulars of all the daily wage employees, including the petitioners who were working in the office, and details as to date of birth, date of entry into service as daily wage employees, category and qualification for respondent. The second respondent forwarded the list of names of daily wages employees to the first respondent. And the same was forwarded and published the list of daily wages, including the petitioners working in the second respondent, by notification dated 5/3/2014. The same was published in the Gazette on 7/5/2015. The case of the petitioner in WP 19, the grievance of the petitioner in WP 1973 of 2020 is that as per the Government of Karnataka formulated rules, Karnataka Daily Wages Welfare Rules 2012, practically Rules 2012, the particulars of the daily wages given the daily wages whose particulars were not proper could make rectification in accordance with the rules and therein, and accordingly a notification was issued. And the daily wages were given an opportunity to get particulars such as date of birth, name, etc. to get rectified. And if so, particulars are sent to the respondent. It is also contended that the petitioners have given their representation, giving the genuine particulars well within time. However, the second respondent has not forwarded the same to the first respondent. The objections are filed by the state government, inter alia, contending that the petitioners have not submitted or raised objections as to their date of birth, which was published in the Gazette on 7/5/2015, or on 11/3/2015 or 14, or published on 7/5/2015, and having not raised any objections as to their date of birth, and having not disputed the date of birth entered in the employment at the time of joining the organization, the petitioner is not entitled for the benefit and contend that the order impugned passed by the state government by the respondent number 1. Who passed that order?
Respondent number 1.
By respondent number 1. And respondent number 1 is not justified. The Karnataka State Servants Determination of Age Act 1974, Section 5 prescribe the alteration of age or date of birth of state service, which reads as under. Subclause 2 indicates, envisages that no such alteration to the advantage of a state servant shall be made unless he has made an application for the purpose within 3 years from the date on which his age and date of birth is accepted and recorded in service register or book or any other record of service, or within 1 year from the date of commencement of this act, whichever is later. The act provided a measure to the state servant seeking for necessary alteration about his date of birth in the service register. As a measure, the state government introduced for the benefit of the provisions of the Karnataka Daily Wage Employees Welfare Act 2012. The name of the eligible candidate, eligible wage employees was published, and the name of the petitioners was indicated in column number 3, and the birth dates of the petitioners were mentioned. The petitioner neither filed any objections to the said notification, which was published in the official gazette, nor has challenged the order notifying the date of birth of the petitioners in the official gazette on 5/3/2014. And in the absence of any objections being filed to the notification published and to the publication in the Gazette on 7/5/2015, the prayer sought by the petitioner seeking to quash the order passed by the respondent number 1 and the order passed by the respondent number 2 is misconceived and does not warrant any interference. Accordingly, this court for past the following note that petitions are read by the impugned order passed by the respondent number 1 stands confirmed. Yes. He was there in the court all that day. He was present before the court that day. So you should at least look into the file. Perhaps he may. Since he's been admitted in the hospital.
Let them make that. I have no objection.
Then this should not be their self.
They have not submitted, they have not.
You should at least look into the file, madam. You should just verify the records. Will you carry it with them, madam? It would be available in the file, right? Or you should ask the other side counsel whether the copy is served. You cannot make such a submission that the copy is not served. And this is not the first time you're making such submission. From morning, is it not? You should be more diligent in making submissions, madam. 34, we are at serial number 28. Now we are at 28. You are in the office of Murlidhar Peshwa, right? So there are some rectifications to be carried out. Is it necessary in all those matters? What are these Copy served, acknowledgement not filed, rectification of office objections. On the objections filed by advocate for respondent number 2. Is just look into that. Just clear it. Petitioner counsel, so and so counsel, on behalf of El Murli, the patient, subjects that learned counsel is unwell and has been hospitalized at Mysore. And on health grounds, he is unable to attend the proceeding. Matter before the court. The submission is recorded at request. Is this matter on? Yes, yes. Twenty-third, 23. 20. 20. Yes. Yes. Final hearing to Is Mr. Ramson here? Okay. Go before the Lok Adalat. What is the settlement now? Then.
Some proposal which was given.
What is this order of dismissal?
The order of the. Was set as. Reinstate. 50% back. That is, there was some settlement, it was sent to the mediation center, but there was, it did not take.
So then how is it possible now?
It was spoken to the advocate, but we say no, if it is not there, then. Go ahead,
Commissioner Council submits that there is a possibility of settlement. And as a final chance, is this matter on 17? It 18th we take other matters, so 17. 18th for reporting settlement if any, or to argue the matter on the 18th. Yes, Mr. Bhinay. It is not so. Correct. They said no such matter, or rather it is not identical, and you have now you have already satisfied certain respondents. Then what happens? You seek for review of their order in the event the apex court holds in your favor. You have already satisfied that amount, right?
That is what.
That is how, even this court has passed an order now. No.
What you're saying is the level is very good, that amount happened, already withdrawn.
Correct.
So one solution is moving up is that still spending all amount of Supreme Court.
No, see, we have been doing this order. We will pass the similar order.
Instead of keeping the matter pending, there are two types. One is.
They have withdrawn that amount.
On the recent time, this all
Yes.
amount which is pending, that can be in the amount. That can be written periodically. Then after either decision in the under Supreme Court, young success, then we take the amount. Take that amount.
Now, in most of the matters, you have satisfied the amount, right? And they have withdrawn that amount.
But even this level of that amount.
No, this court has passed one order. They said, they have to pay the amount. See, already withdrawn other someone. Withdrawn, we can't ask them to deposit and,
Succeed. Permit us to recover it.
other line. No. That is not
possible.
Practically, law also doesn't permit that.
He succeed. That's the order we want. I'm also making the same submission that it is not at all possible to recover. But let there be an order. That is one submission with regard to those who are withdrawn the amount. And other matters
See, it's not permissible. Once you pay that amount, where is the question of recovery?
Practical problem.
Then you implement for the further future, not for the present.
Practical problem.
They are all retired long back. They are not paying the gratuity amount. Regularization period ge illa ado alla.
The amount has been paid, ECR has been paid. They are claiming that the person who are working worked as a daily wage from that period to till they are absorbed. That particular period they claim after that. And moreover, as soon as the order passed by the controlling authority, then thereafter we have to deposit to file appeal. And appeal
we will not ignore it. Which amount they have withdrawn, that you are not entitled. In light of Andre. So even in the event, what happens? Nothing will happen. Even if you succeed in your reputation, in your no, we are not going to. Coordinate bench, then correct. We respect the coordinate bench order, but in this matter, we will not pass such order because once the amount has been already paid.
The problem is that, my lord, as soon as the appellate court passes the appellate authority, they are not going giving the certificate copies in time, stipulated time. And before we take the certificate copy, file the rectification deposition order, they will hand in close with the party. I make a direct allegation against the controlling authority as well as the appellate authority. So now the rectification ready ಮಾಡಿ ನಾಳೆ rectification ready ಆಗಿದೆ. ಅದಕ್ಕೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ. ವಾಸವನ್ನು ಬರೋರು ಇದುವರೆ ಅವರು ಹೇಳಿದ್ರೆ ಇಲ್ಲ ಇವತ್ತು ನಾಳೆ ಅಂತ ಅವರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. By that time they will take the money, they will release the amount. That is the problem.
Serial number 1 ನಲ್ಲಿ ಏನಾಯ್ತು ಹೇಳಿ, 13 ನಲ್ಲಿ ಏನಾಯ್ತು? First matter ನಲ್ಲಿ ಏನಾಯ್ತು? Amount is withdrawn.
2014,
withdrawn. Tired. This is which matter you are saying? 40242. The serial number 30.3. 30.3. 30.4. 40.4. He said that amount is already withdrawn.
Whatever the order was with the coordinate rules, that can be followed by law.
Well, we are unable to trace the error.
What do you say for that order of the coordinate bench?
We already taken the amount.
Why succeed in this without then I may not permit to cover, but it is not at all possible. But
Then his LRs will come on record. His LRs will, he's already dead. That is what I was asking you, which is that order which I passed. We have also passed a similar order. We will say that. In all these matters or only in that matter? So you just tell in the afternoon which are the matters they have already withdrawn the amount. So we will say. In all your matters they have withdrawn? They are already dead and done. What to do then? We will say, we will dispose of this writ petition, saying that in the event the apex court holds or you succeed in the petitions before the apex court, the petitioner are at liberty to seek for appropriate actions against it.
Yes.
So that we will.
Those who are withdrawn and maybe publicly withdrawn.
Otherwise. Now, if they have not withdrawn, they are not. If they have withdrawn, the question of keeping the amount in deposit would not arise. So in the event they have not withdrawn, we will say that the amount to be kept in fixed deposit.
Whatever the
interest,
they can withdraw. And after the final decision, then whoever succeeds, they will.
Yes. Who? And then what to say? You have to get the LRs on record then. Amount, then you will be getting the interest. Then what to do now? See, otherwise we have to say it is abates now. You will not be entitled. What should we do? Yeah. Now all the petitions are by the assistant executive engineer and others, directing them to pay the gratuity amount from the date of appointment till the date of regularization. How is
Period for which they work as a daily
wages? Daily wages. With what different amounts were ordered?
Yes, different amounts.
So we will say nothing about the amount. We will say
that would be
the petitioners. In all this, all the petitions are taken up together as common questions are involved. In all these petitions, the petitioners are the assistant executive engineer, assailing the correctness and assailing the legality and correctness of the order passed by the controlling authority or the appellate authority, both passed by the controlling authority and the appellate authority, directing the petitioner to pay the gratuity amount prior to regularization. Learned counsel for the petitioner, Sri Bhimaya, submits that the question as to whether the period prior to regularization to be counted for the purpose of gratuity is pending before the apex court in SLP civil diary numbers 9156 of 2023. In all the matters, government is there, certain persons are served. Certain claimants have already only served unrepresented. In certain writ petitions, the workmen have been represented by counsel, and certain petitions they have been served and unrepresented. The learned counsel in WP 4024, learned counsel for the respondent in WP 40242 of 2014 has filed a memo stating that the gratuity amount has already been dispersed, towards the daily wage period, and the petition has become infructuous. The pendency of the special leave petition involving the question as to whether the service rendered prior to regularization could be counted is pending before the apex court in the case of what? 916 and just furnish that copy at the body 9156 is assistant executive engineer CNML versus CD Srinivas. That is pending. Applications are pending. That has to be amended. In certain matters, certain matter services are not completed. So you just now that we are not, no harm order has been passed against them. We in light of the order, in light of the withdrawal of the in WP 402 of 40242 of 2015 by the respondents, and in the event the apex court holds that the period and in the event the petitioner succeeds in the petitions before the apex court, it is open for the petitioner to initiate appropriate action insofar as the claimants having withdrawn the amount already deposited by the petitioner. The in relation to the amounts which have been deposited by the petitioner, by petitioner before the controlling authority, the learned counsel for the petitioner placed reliance upon the decision of the coordinate bench of this court in WP 11911 of 2023 in the case of Assistant Executive Engineer versus Assistant Labor Commission and others, dated 9 August 2024, and submits that the amount in deposit be directed to be kept in fixed deposit, and the interest to be released in favor of the claimant. The such submission is recorded. Learned counsel for the petitioner submits that in identical matters, the coordinate bench of this court has disposed of the writ petition granting liberty to the petitioner to initiate appropriate action if the petitioner succeeds in the petitions before the apex court. In the case of WP at the heading here, 23822, the coordinate bench of this court in WP number 43822 of 2016. In the case of Assistant Executive Engineer, this is Deputy Labor. With the court deems it appropriate to dispose of the writ petition with the said observations. the petitions are disposed of. The amount in deposit, the amount already withdrawn by the claimant. And in the event the petitions would become infructuous, and in the event the petitioners succeeds in the petitions before the apex court in 9156 9156 of 2023, the petitioners are at liberty to initiate appropriate action in accordance with. And the amount the amount in deposit made by the petitioner before the controlling authority. The said amount to be kept in fixed deposit in any nationalized bank in the name of the controlling authority, and the interest that may accrue in the said deposit to be released in favor of the claimant applicant or applicant on proper identification. In the event the petitioner succeeds in the matter before the apex court, the petitioner is entitled for refund of the said amount. And that's all. And in case it is stated that the applicants have expired, the legal and heirs of the applicant are entitled, and the amount in their favor to be released on proper identity. The applications, LR application 30.1 ನಲ್ಲಿ I is 1, respondent number. Just in those applications, tell your colleagues, colleague to say as to which are the applications which are pending regarding legal heads. Legal heads applications are pending, so we have to allow those applications. So just yeah, and you have to amend the cost title also. 30.1. I1 of 2014, 2 of 2014, and 3 of 2014. 30.1 ನಲ್ಲಿ. So just we'll take other matters at 2:30. The connected matter. Please this allow. Your colleague was here and he said partial submission. There's the other side. I think she was. This matter week after next. Serial number 12. You did not mention 21 interim order granted earlier is extended to the next day. Note for you. This afternoon will come in the afternoon. Continue now. ಯಾವ್ದು memo for withdrawal ಯಾವ್ದು ಐತಲ್ಲ cost. ಅದು ಮತ್ತೆ just a moment. One passed over matter, serial number. What is that? What is the order under challenge? What is the order under challenge? What is the order under challenge? When a counsel KV Satish Chandra has filed power for the petitioners 1 and 5. When a counsel Satish Chandra seeks to withdraw the writ petition insofar as petitioner number 1 and 5 as contending that the matter has been amicably settled. The memo of withdrawal is signed by the petitioner number 1 and 5 who are present before the court. Memo of withdrawal reads as under. In light of the memo file, a submission and memo file, the petition is dismissed as withdrawn in respect of petitioner number 1 and 5. The petition continues in respect of other petitions. Next, yes, what is that? Sign order sheet. Sign order sheet. Huh? Yes, madam. Madam, you are the petitioner. They say the writ petition is not maintainable. You have not approached the appropriate authority. You should take instructions and come. How many petitioners are here before the court? Petitioner counsel has filed amended cost factor. Office to verify and proceed. Yes, please, at the request of the petitioner counsel, list this matter on 17. One person says. They have produced one. No.
That is the we have to accept that. So, Manoj, things fall from that circular. One, and we've addressed in our
in light of that circular, you would not be entitled for recovery of that one person says.
It falls. The circular addresses the issue of timing only. Now, I also see page 9, hello, which has the table.
Page 9. What does the circular indicate from which period to which period the circular? So that's all the crux of the petition now.
Two issues, hello. One is the time period. Second is post the time period. If the cess is to be levied, then on which part of can you levy the cess? Is it only construction? Can you also levy on supply, erection and other costs?
Now let us first think about, let us deal with the time period. Time period.
You see that
yes, 5 project site.
Yes. So my lord,
offer submitted on 8.
1 and 2, my lords, are prior. I mean, they didn't have
so undisputedly it is prior and there is no
4 and 5, then circular filter comes afterwards and they are therefore entitled to levy their cost.
That is serial number 3
4 and 5.
comes after.
So the date of 1/11/2006.
Correct as per the circular. The
Circular
present.
dated 27/8/2006. So if it comes after 1/11/2006, then their cases that the levy should be allowed.
So if it comes after
Yes.
1/11/2006,
Yes, ma'am.
then you are entitled for
Payment only on construction.
only. So let us come to the serial number 3 to 5. So it comes after 1/11/2006.
But the date of acceptance is all after 1/11.
Is it date of submission or date of acceptance?
According to the memo, that work, it says in view of the above, it is hereby clarified that work entrusted to the contractor prior to 1/11. Now, what is work entrusted to the contractor? If you make it a letter of acceptance, we come after. If it is the offer is submitted, then we.
Where did you read the circular? Which paragraph? Yes, is that memo along with
Last paragraph.
after issue of the above amendment, number of requests have been found. No, last paragraph.
In view of the above, it is hereby clarified that work entrusted to the contractor prior to 1/11/2006.
Work entrusted to contractor would be only after the acceptance.
Let us take it for a moment that it is after that.
So interested is after.
Fine, that is the matter of semantic. Now let us take it so that I want to just convince you lots of on the issue of what is this 1%. Let us say now, I want to go back.
No, let us now come to which are the sites which has been applicable now. So work was entrusted to you when 8th December 2006. So that is after 1/11/2006. So this is applicable.
3, 4, 5. Kaungati, Vajramati, and Hubi.
So all the three, it is applicable.
Yes.
So
yes, 1% can be issued.
1% can be issued.
Now, my lord may, as per their, my lord may now finally come to the other table on page 16.
Page 16.
Yeah.
Yes.
Now, have page 16 again.
Yes.
Same. Now, we are again looking only at 3, 4, 5, my lord.
Yes. Only
Now,
3,
my
4,
lord,
5.
yeah, they have very clear. Not only 1% of civil, but they also levied a supply and EPC erection.
So according to you, the supply and EPC erection would not count.
Absolutely.
Only the civil.
Yes.
Where do you find that?
Because that is in the Supreme Court decision I have handed over.
Yes. That is Power Transmission Corporation. So even if the cess has been levied, it has to be only on the civil.
Only on the construction, not
Only
on
on the-
supply and not on erection. Because we go to Para 51 onwards, my lord, I will. My lord has Para.
Yes.
Page 33.
Yes.
The clear statutory scheme of the BACW Act excludes the supply contract from within its ambit. On behalf of the respondent one, it is pointed out that several public authorities and corporations, such as the Delhi Metro Rail Corporation and the Karnataka Power Plants, even
includes.
the respondent hearing is a reference, have issued instructions that no cess under the BOCW Act is leviable on a contract of supply of goods.
Yes.
Copies of the KPCL circular to the back are annexed. Now, if we turn over the page, Para 53. Cess under the Cess Act, read with the BOCW Act, is leviable in respect of building and other construction work. The condition precedent for imposition of cess under the Cess Act is the construction, repair, demolition, or maintaining of and or in relation to a building or any other work of construction, transmission towers in relation into the area of generation, transmission, distribution, mere installation. My lords has that.
Yes, yes.
Mere installation and or erection of pipelines equipped for generation of transmission, for distribution of power, electric wires, transmission towers, etc., which do not involve construction work, are not amenable to Cess. So it should only be insofar as the construction, supply and erection methods. There cannot be a levy of that 1%.
So now, according to you,
Go back to that table, my lords, and page 15.
levy of cess of 1%, though is it applicable to you, it would be only in respect of civil. That's all right.
Absolutely. So therefore, in Paris.
So you don't dispute that now there is a cess to be levied.
And that is I have to be refunded only supply and election cost. So far as Saudati Vajramati and Pukriya. So far as they go and it has the objection, they said that they will pay it back. And my learned friend has said that to take instructions on that. Now, I just want to point out also that our High Court has also taken the same view on supply following the decision of the Apex Court. I will have following the Voltage Limited manner. If the submission was made on the last case that these decisions may not be applicable to Karnataka, not with the our own High Court, running page 5 manner.
Yes.
Paragraph 4.
Yes.
Even though the petitioner's deduction of 1% tax under the Act is impermissible, having regard to nature of contract, that is the execution of contract with supplying, installation, commissioning, ventilation, in identical circumstance, if it's spoken in case of Uttar Pradesh power transmission, that is the decision I just cited, that is applicable, has taken note and held a reduction of 1% tax provision is not warranted, it will not attract in respect to supply of materials and where there is no consensus. There are other decisions I have handed over, but they all say the same thing. If I fall after that date, then yes, I am.
You are liable to pay 1% cess, but
not on supply.
Yes. That's all right. See, 1% cess. Yeah. Yes.
Right? Deducted as labor space, taking into account supply portion of the volume, whether it is less. I respect the ability to numbers of grounds. Number one, all these terms, there are challenge notifications. And there is a declaration clause. Such prayer is not part of this project. Second, my lords, on the ground of the KPTCL in the Supreme Court judgment, my lord,
Yes.
one minute. The triggered statutory use the tax to supply contract of standard. On behalf of R1, it is pointed out that several of the authorities and corporations as delegate for reform have issued instructions that no cell under the Act levy or contract of the copy of the case in circulars dated 22/8/2012 and 28/8/2012 to the
this is next to the rejoinder of the R1. Can we see 28 where the reference to now, my lord will find this 28 is 2015 A1 for a moment, my lord will find is
Of
the petition. Section N, start from page 1.
yes.
In 51, my lord, we directly see item number 10. My lord, get the 28/8/2020. Definitely, item number 10 gives reference to 28/8/2012. This has been amended. Kindly see the reference on page 53. Page 53, my lord, para 8. By circular dated 28/8/2012 and rendered serial number 10 above. Was further clarified that erection portion of the term contract also contains works which are in the nature of construction work, and hence refund claim of ground-keep contract shall be processed only in respect of supply portion.
Correct. That is what the submission of the petitioners is. See, you don't levy the cess of 1% on the supply and the erection, but you can levy the 1%. No, there's nothing which you have to argue now in this matter, Mr. Counsel. All the time, the KPTCL have been representing the court that 1% of cess, they will not be implied on or imposed on the supply. Now you can't take a separate, different stand. And that says supply portion. So there's nothing that you have to argue in this matter, Mr. Counsel.
What happened after?
No, you cannot just argue for the sake of arguing. It is, Suresh, with your name is Suresh, right? No, you can't argue anything which is not there now. See, all the time, all the counsels appearing for the KPTCL have been representing the court, stating that 1% cess which has been levied on the supply, they would withdraw that. Yes. These all judgments were passed after 2012 itself.
There is no challenge to any of
they may not challenge that notification when all the time you have been representing before the court.
Yes. Can we see for a moment? Clear thought in that petition, that matter itself. The High Court, can we really find some external language differentiating on what ground this not
we have nothing, but then we have to say that the 1% cess can be issued, which comes after 1/11/2006, and if at all it has been after 1/11/2006, it would be only to the limited extent of construction and not supply and nothing else, Mr. No, not made up our mind. We have looked into the records.
I only bring it to my lord. Which first can we see that petition to the High Court of Karnataka what was sought by the
We are not even looking into this order. We are just going on the merits, your notification, your circular, your contentions, the judgment of the apex court, only on that ground. What your circular say? No, what does your circular say? Come to your circular. Come to your circular. Come to your circular. Yes, we go to the order. 27.
Circular dated 28/8/2012. And that is what is said, what was said dated by the Honorable Apex Court panel is dated in para 8 of the order.
When was the circular issued according to you?
The next page, 8/1/2012. Can we see, let me just read it.
Just read it. Para 9. In circular dated 2013 circular is also referred. Further instructions were issued to regulate refund of Cess at 1% on supply portion. This was amended. It must be challenged. It must be subject to challenge or a declaration has to be sought, like in the other petition before the Sovereign Court. Since many contractors are requesting KPTCL to refund the Cess amount collected for tender works awarded prior to 1/11/2006, after so many years, before 1/11/2006, if they are going to ask everything, then it's a problem for the entire state. And then we see why this amendment. The same has been examined for issuing amendment. Even if the order 25/6/2007, in line with GO order page 18/1/2007, and with reference to the clarification issued by the Labour Department, hence this order. This order is passed. This order has been clarified in the 2016 circular, which has been none of this has been challenged before any court of law in my respectful submission. None of this has been held to be violative of principles enshrined or violative of the Constitution. None of these circulars has been challenged. Neither a declaration has been sought. In such circumstances, my lord, I ask myself if this honorable court can allow the prayer sort of it. That is my respectful submission. My lord may consider and pass a public order, my lord, but the submission is this. That in light of the law and the law in Karnataka, and kindly see the Supreme Court, my lord, in UP, there was no notification of circular.
This is now not very acceptable on your part. Yes.
On the fact that
Yes. So how much is the refund now that you would be entitled to? That, no, it would be now only for the supply and erection. So how much would be the amount? We will just say that Saundati, Vajramati, Hubballi.
and taking an enhanced
Full amount, that would be your entitlement.
Yes. Hello? Here is not correct.
We are sitting in Article 226. Yes.
You are surprised.
We are not in a civil, we are not against an order of a civil court order, is it not? Yes. See, what they are entitled, they are entitled. You can't change anything what is not there. A submission is in light of the notification dated.
Yes, and that has been
Annexure L, page number 53.
and that has been amended later on. My lord saying here to go. And my lord clarifies all the. Therefore, my lord.
Just a moment. Annexure L, bears the notification dated 12/7/2000. Which is that notification?
Notification dated 1/1/2000.
No. Which is that reference in the QP?
Yes, 28/8/2012.
28/8/2012. Where's the notification? Annexure L, where's the notification dated 28/8/2012? What does it say according to you?
That has been amended. And my lord follows 8/1/2012.
Correct. This also says regulate refund of cess of 1% on supply portion. Doesn't say about erection and anything. Correct. Ultimately, what did this notification say? It said that they are entitled for refund of cess of 1% on supply.
So amended, can you see the next page? This led to an amendment because of the reasons are in there. Because of reasons in there, the amendment was given to this. And it did not say subside. Time is recovered and remitted in respect of erection and supply portion.
Can we see item number 3, in respect of such works, entrusted to contractor prior to 1 level yes, at 1% of supply portion, it has already been recovered and remitted to welfare board, should pay the refund from the welfare board by the concerned accounting. Refund of the same to the concerned contractors should be arranged to be accounting the amount as welfare board. This was again amended to say prior to 1 level of such work entrusted. Prior to. The work has to be entrusted prior to 1 level.
Correct, that is not in dispute.
On supply.
See, on supply portion, in respect.
What? Erection and para 3 may not talks about supply portion. In underline.
Yes.
On supply portion also there is a law data. This notification.
We will answer. Yes. The petitioner is before this court for the action of withholding the principal amount of rupees 78 lakhs 76,057 as 1% sets towards the supply portion of the project. Supply also towards the supply of goods under the building and other construction workers, practically regulation of employment and other condition of service, bracket complete, Act 1996, POCW Act. POCW Act for fraud. And the rules framed thereunder, POCW rules. Next one. The respondent, Karnataka Power Transmission Corporation Limited, Corporation for short, issued work orders to the petitioner in 3 categories. 1, contract for civil works. 2, contract for supply of materials. 3, contract for erection work. The work related to various turnkey URNKE projects for the development are establishing substation at Begu, Nimans, Saudati, Vajramati, and Hubali for the purpose of generating and supplying electricity. The timelines leading into the execution of contract for each of the projects are set out as below. Page number 9. Page number 9 of the rectification. The respondent issued separate orders in respect of the projects, each project, that is letter of intent for supply portion, erection portion, and civil works. And the petitioner furnished separate guarantee and separate orders were placed by the respondent in respect of each contract. The government of Karnataka, in light of the enforcement of POCW Act, filed notification dated 1/11/2006, formulated the building and other construction workers, regulation of employment and condition of service, Karnataka Rules 2006. And thereafter, the Department of Labor and Welfare by government order dated 18/1/2007, directed as under. Page number 10. The government order issued by the Department of Labor and Welfare on 18/1/2007 held where the tender has been submitted or finalized and the work is awarded prior to 1/11/2006. 1% cess was to be paid by the respondent. The petitioner commenced execution of work as stipulated under the contract of each project on terms and conditions more particularly, set out in the contract executed under each project. In light of the enforcement of the OCWR and rules claimed thereunder by the state government, the respondent commenced deducting of cess at the rate of 1% at the total value of each project. The cess was to be deducted at 1% of the cost of construction as set out in the rules of BOCW rules. Rule 3 of BOC stipulates that the cost of construction, inverted comma, includes all expenditures incurred by the employer in connection with the building or other construction work and does not include the cost of material used in the construction, the petitioner coming to know about the said fact, when the payment for the bills was raised by the petitioner in December 2007, were released by respondent in January 2008. Illegal deduction was noticed by the petitioner. The respondent issued clarification to regulate the refund of 1% cess on the supply portion in respect of the tenders invited and bar finalized and works awarded by the respondent. The relevant portion of the letter is as under page number 14. Para 16 minutes. The respondent further clarified by the circular dated 8/1/2015, where the tender submitted or finalized and work is entrusted to a contractor prior to 1/11/2006. In such cases, 1% cess has to be paid by the concerned division to the board as mentioned. Then a counsel for the petitioner submits that the issue involved in the matter is no longer a res integra. In light of the decision of the apex court, in the case of yes, Uttar Pradesh Power Transmission Corporation Limited versus CG Power and Industrial Solution Limited and another, wherein the apex court has held that a contractor who enters into a pure supply of contract is statutorily exempted from levy under BOCW Act. Further, mere installation and or erection of pipelines, equipment for generation or transmission, or distribution of power, electric wire, transmission towers, etc., which do not involve construction works, are not amenable to cess under the Cess Act. The apex court at para number 51, 53 has held and 54 has held as under. Then a counsel appearing for the respondent corporation makes a distinction and submit makes a distinction and places the circular issued by the respondent on 27 May 2016 to contain that by the circular it has been clarified that the work entrusted to the contractor prior to 1/11/2006 is the ultimate criteria cutoff considering refund of cess amount as per the amendment issued on 18/1/2015. In the instant case, as stated supra, the extract the particulars of the project and the labor cess is deducted by the respondent and the date of offer made by the petitioner and the letter of intent issued by the respondent and letter of acceptance issued by the petitioner is as under. Page number, para number 5, project size, offer submitted by the petitioner, letter of intent issued by the respondent, letter of acceptance issued by the petitioner, other chapter. Then labor cess deducted by the respondent, the supply, erection, civil, total cess deducted by the respondent. You have to insert this. This is in para 26. The as stated supra, in the case of short name would be Power Transmission Corporation, stated supra, the apex court has held that the condition precedent for imposition of cess under the Cess Act is the construction, repair, demolition, or maintenance of and are in relation to a building or any other work of construction, transmission towers in relation inter alia, generation, transmission and distribution of power, electric lines, pipelines, etc., and mere installation and or erection of pipelines equipment for the generation or transmission or distribution of power, electric wires, transmission powers, etc., would not involve construction work and are not amenable to cess under the Cess Act. Underline. The project of Bevur and Numans is prior to 1/11/2006, and as such, the petitioners are entitled for the entire stress deducted by the respondent. In respect of the projects at Saundati, Vajramati, and Hubballi, the 1% cess applicable to the petitioner is only in respect of civil constructions and not the supply and erection as deducted by the respondent. For the foregoing reasons, the respondent to refund the cess deducted by the respondent to projects at Saundati, Vajramati, Hubballi in respect of supply and erection. That's all. Accordingly, with the said observation, the writ petition stands disposed of. The respondent to refund the cess deducted on supply and erection within a period of 2 months, 3 months. Failing which the petitioner is entitled for interest at the rate of 6% after you don't pay that amount. Yeah. Commissioner Meno. Petitioner counsel to rectify the office objections within a week. Yes. So, in light of the urgency pleaded, the matter is taken up for preliminary hearing. Sure. You're a company, na? Who are you?
Now what I have established it in 1984. When it was established, there was no town. Now the town came here in Alemane. Therefore, though there was no nothing, it was
Alemane is that Jaggery unit.
Jaggery, I was having trade license. I was having a consent from the pollution control board. Well, one person filed a complaint before the pollution control board that there is a pollution in the village. Based on that, I was directed to comply with certain directions. That establishment of trial way, and I was directed to establish. When was the I'll give a feedback. After he filed a complaint before the Lokaयुक्त also. And Lokaयुक्त made an inquiry and they stated the other way which is established clear to 2019 does not require all those complaints. But in the meantime, I have complied with the directions issued by the pollution control board.
Everything is complied.
Everything is complied. Thereafter, they have issued a form also to me. Now, that person who was an extortionist from me because he was an extortion, he was trying to stop and he the register. After complaints, after issuance of consent form, he again goes and makes the same complaint for the authorities. In the meantime, I have filed an application for trade license expired. Trade license, though I have applied in 22/5/2024, the authorities, that is the PDO, didn't give any reply. He kept quiet. But once this fellow extortionate files a complaint again, but he's running without the and there is pollution. Now, since earlier he has filed a complaint against PDO, pollution control board authorities. For everybody, he has filed a complaint before the Lokaयुक्त. Well, coming under his pressure, the pollution control board authorities have issued one notice to me, which is a connection J, page number 53, stating that asking me to install one machine called OCEMS. Well, that machine will cost 60 lakhs rupees. But in fact, this was as per the guidelines of the Karnataka Pollution Control Board that needs to be installed in 17 segregated industries. That is, that guidelines also have applied. In fact, consent form says it's a green industry because it is a consent formula to show that it's a green industry. The Russian kindly come to page number 40, annexure G, page number 44.
Page number
42. Page number 42. Last only one box there. Consent order number so PCBID industry colors green small scale. 24/4/2024 consent formula. This OCEMS will not apply to me. Therefore, I have challenged you before the total number 1. It is pending consideration and it has not been posted because this was issued later. I have challenged it little later. Now, we are taking the shelter of this. The Super issues a notice to be calling upon me to stop the industry because he has filed a complaint again that extortion. There is a 6th respondent. I have again filed a complaint. Now, your Russian kindly come to annexure B, page number 66. Yes. This Subarkupe Gram Panchayati PDO, who has no authority, writes a letter to the AWE of the Chester asking me to stop the electrical collection. Lord, your Russian kindly come to last page, 67, last page, last paragraph. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಗಳಾದ ಸೂಕ್ತವನ್ನು ಪಡೆಯಲು ಆಲಯವನ್ನು ಶಿಕ್ಷಣ ಗ್ರಾಮ ಮತ್ತು ಮಂಡ್ಯ ಜಿಲ್ಲೆಯ ಆಲಯವನ್ನು Based on this letter, now the annexure 2 is issued.
What is that appeal you have preferred? What is the appeal you have preferred?
This appeal, because I have filed the connection key is the application given by me for renewing of trade license and 2024. He keeps quiet and he doesn't do anything. He's supposed to pay Gram Panchayat and he issues an endorsement on 1/8/24 that it is in abeyance. Now, my lord, as per the Karnataka Panchayat Act, 70 subclass 2C, if deemed to have been granted, it is not by so based on that, I filed an appeal because he issued the endorsement and challenged it. But for that matter, the EO who is afraid of this extortionist, even he has not given a number also since I am fighting 88. Similar was the situation in one big prison where I only appear. You asked for exactly the same situation, it's a different concept. This was a similar situation where building license were given. Same situation on his lordship have lost the same honor on the first day itself. Not issuing the directed petition, this order was passed. Placing the submission made that page number 88. Placing the submission of the land council for respondent number 2 on record, this tax disposed of with the specific direction to respondent number 2. Executive officer,
No, you have challenged that order also. You are seeking some direction to consider your appeal as well in this petition.
Yes, correlated. Last week that I should file a petition. If you tell him to file the one which submit product ನನಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಎಲ್ಲ ಸೇರಿಸಿ ಮಾಡಿದ್ವಿ.
When did you establish your unit?
1984. The conversion order is in page number 84.
1984. 1984.
Yes. Section A is the conversion order. Immediately after this, I have established. It is running from 1984. And the annexure B, it was the earlier consent order. That was up to 62, 2022, annexure B.
Annexure B.
B was the consent form. After a time and again, the review was available. But general license was also there. Annexure B1.
At the behest of whom the connection has been disconnected? Or it is who is that person on whose behest the notice
responding? Yes.
He is a complainant.
His complaint. But his complaint have been redressed. Though it was lordship may kindly come to look at the report which I have produced for the yes, otherwise the green belt store the case. Green belt close for the complaint. I don't know how she got it. The lordship may kindly come to look at the report which is at page number 34.
34.
I will take your lordship to paragraph number 44.5. ಐದರಿಂದ 7ನೇ ಎದುರುದಾರರು ವರದಿಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಆಲಯ ಮನೆ ಮಾಲೀಕರ ಮೇಲೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಪಿಡಿಒಗೆ ಸೂಚಿಸಲಾಗಿದೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿಯವರು ಆಲಯ ಮನೆಯನ್ನು ಸಾರ್ವಜನಿಕ ತೊಂದರೆಯನ್ನು ಕಾರಣವನ್ನು ಕಂಡುಕೊಂಡಿದ್ದಾರೆ. ಆಲಯ ಮನೆ ಮಾಲೀಕರಿಗೆ ನೀಡಲಾಗಿದೆ. ಅರುಣ್ ಮತ್ತು ಕುಟುಂಬಗಳು ಇಮೇಲ್ ಪದೇ ಪದೇ ಅವರ ಹಾಜರಿರುವುದಿಲ್ಲ. ವಿದ್ಯುಚ್ಛಕ್ತಿ ದೊರಕದ ಕಾರಣ ಸರ್ಕಾರ ದೊರಕದ ಕಾರಣ ಅಪೀಲ್ ಸಾಧ್ಯವಾಗುವುದಿಲ್ಲ. ಆಲಯ ಮನೆ ಮಾಲೀಕರು ಮಾದಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳುತ್ತಾರೆ. ಆಲಯ ಮನೆ ಮಾಲೀಕರಿಗೆ 27 ಕಾರಣಕ್ಕಾಗಿ ನೋಟಿಸಿ 15 ಲಕ್ಷ ಮುಂದುವರೆದು ವಿದ್ಯಾ ಪರಿಸರ ಅಧಿಕಾರಿಗಳು ವಲಯ ಕಚೇರಿ ವಹಿಸಿಕೊಳ್ಳುವವರಿಗೆ ಸೂಕ್ತವಾಗಿ ಪತ್ರ ಬರೆಯಲಾಗಿರುತ್ತದೆ. ಕೇಂದ್ರ ಮಾಲಿನ್ಯ ನಿಯಂತ್ರಣ ಮಂಡಳಿ ಮಾರ್ಗಸೂಚಿ 13/2019 ಮತ್ತು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಮಾಲಿನ್ಯ ನಿಯಂತ್ರಣ ಮಂಡಳಿಯ ಅಧಿಸೂಚನೆ ಈಗಾಗಲೇ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಆಲಯ ಮನೆಗೆ ಮಾರ್ಗಸೂಚಿಗಳು ಅನ್ವಯಿಸುತ್ತಿಲ್ಲ ಎಂದು ಮಂಡಳಿಯ ಕಾನೂನು ವಶದಲ್ಲಿರುತ್ತಾರೆ ಎಂದು ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. Now we have based on this, this complaint was closed by the Honorable Lokaयुಕ್ತ. This was the report. Now, paragraph number 46 ಅಲ್ಲಿ you must kindly see paragraph page number 46 page
your
number
trade license your trade license is kept in abeyance.
Abeyance is pending because the 25/24 Act 19/24 there is no response. 60 days ಮುಗ್ದೋಗಿದೆ. 70 subclass 2 will be applicable. So 70 subclass 2C. That portion I have extracted your lawsuit for the levy reference. Lawsuit may just take your lawsuit that portion out.
Who appears for the respondent number 2, 4, 5?
Procedural appears for the Panchayat level, that I know. India Jilla Panchayat normally takes notice. 2 to 4, so Soviaji may be directed to take notice.
The CGP is directed to accept notice for respondent number 1. Somyaji for respondent number 2 and 2 to 4. 2 to 4. 5 yaru. Chamundeshwari.
Chescom ಗೊತ್ತಿಲ್ಲ ನನಗೆ. Chescom ಗೆ reference because normally
Chamundeshwari.
will have permitted to take emergency. Accept by anything.
Issue emergent notice to respondent number 5. In addition, the petitioner counsel is permitted to serve the reputation papers on the standing counsel appearing for respondent number 5 and file an acknowledgement to that effect. Issue emergent notice to respondent number 6. Then a counsel for the petitioner taking the spot to the writ petition papers contends that the petitioner has established a Jaggery unit and has been considered as a green unit as per the Karnataka State Pollution Control Board as per Annexure H. Then a counsel submits that the respondent number 6 had approached the authorities by filing complaint, and one such complaint has been filed against the petitioner before the Karnataka State Pollution Control Board and the KPCB and the KPCB has on the complaint filed by the 6th respondent has issued notice by communication calling upon the petitioner to install OCEMS and provide camera at the entry of the industry and inside the Jaggery unit. As the petitioner's trade license was expiring, was to expire, the petitioner submitted an application for running for the issuance of for extension of the trade license. The 4th respondent on the application has issued an endorsement stating that the trade license is kept in abeyance. The aggrieved by the endorsement issued by the 4th respondent on 8/8/2004. The petitioner has approached the 5th respondent by filing an appeal. Has filed an appeal. You have filed an appeal, Allah? Yes. As 5th, Allah? The aggrieved has filed an appeal. Has filed an appeal, and the same is pending consent. It is stated that the 5th respondent, assistant executive engineer, has issued a notice calling upon the petitioner to stop the Jaggery unit on 7/8/2024. And the petitioner has submitted his reply to the notice by stating that under section 70 subclause 2 subclause C of the Karnataka Rural Development and Panchayat Raj Act, it is if the application is not considered within 60 days, it is to be deemed to have been granted. At this being the state of affairs, at the behest of sixth respondent, the fifth respondent has, Chamundeshwari, has issued a notice calling upon the petitioner to produce the license, failing which the electricity connection would be disconnected. When a counsel for the petitioner submits that in light of the notice issued on 6/9/2024, the petitioner apprehends the disconnection of electricity in the circumstances made out, as there is a threat of disconnection of electricity connection. This court deems it appropriate to stay the further proceedings pursuant to the notice dated 6/9/2024. Till the next date of hearing, and the petitioner to continue to pay the consumption charges. And delivery granted, permitted.
Because this case also.
Not in this case. Is Mr. Banu Prakash? Has been. When did you give a proposal? First you have to give, then say it before the court. Counsel for the petitioner submits that a proposal for settlement has been given to the respondent, and they would explore the possibility of settlement. To report settlement, if any, or argue the matter, this matter, or 24. Termination. Working as an electrician. West Comma. Yes.
I was again retransferred to this responding to this. What happened was
Third transfer. Yours is third transfer. So your
issue is in relation to four charge sheets
issued by the management of Minerva.
Yes.
After your transfer.
Charges are very easy and clear. I have explored four charge sheets. When you look at the first charge sheet, it is connection A without page 18.
Yes.
This is dated 10
Who appears for the respondent? The Narasimha Swami.
Reported that you are designated as electrician and you are disobeying the instructions of the department of affairs. Also refused to do the allotted work in the department providers. You were advised to the department head as well as personal department the allotted work. In spite of the same, you have refused to obey any instructions to the department staff or effecting the allotted work, and you were loitering in the CH-27 without doing any work. Earlier, you are suspended for 2 days. Today, dated 3/8/2002 for disorderly behavior with safety officer in connection with not wearing the uniforms. Again, you are also warned by video letter dated so and so for misbehaving with security officer. So this is all the charge. So it does not disclose the details, my misbehavior, the persons with whom I have misbehaved. Nothing of that sort, not the is contained in this charge sheet. Then, I submitted a reply in the next document, actually one. I raised the very same contention saying that it's very vague charge and does not disclose any particulars or details of the charge. This is the sum and substance of my reply. Then, I was issued one more charge sheet at page 23.
It was in when 10/2/2002.
Yes, sir. 10/2/2003.
Okay.
Then, after that, I was also kept under suspension. Then, my lord, the suspension was revoked on 16/10/2003. Then, thereafter, this second charge sheet was issued on 13/1/2002, which is at page 23. I'll just read two paragraphs.
Yes.
Charge sheet from suspension pending inquiry notice. You are working as electrician in motorhomes department. It is reported that you are in the habit of not obeying the instructions orders issued by your superior officers. Also refuse to attain the work allotted to the department.
Similar charge.
Similar charge. Honored, as per the second part of the charge is concerned, is paragraph 2. On 7/1/2004, it is observed by the personal manager of companies and motorhome supervisors who are discussing on certain issues that you entered the chambers of the personal manager and therefore you instigated the workers and asked them not to work and forced them to go on for a cool-down strike. This is not proved. The inquiry. Second charge. Then, thereafter, one more charge sheet was issued. Please see page 30, annexure C.
3 charges levied again.
4 charges.
Or similar again?
Now, as far as this third charge is concerned, it was dropped. I cannot probably watch the reading third charge sheet.
Third charge sheet is at page number?
Page 30.
Please. This has been withdrawn.
This has been dropped. Then, the fourth charge is at page 31, annexure D. Annexure D. This is also very flimsy charge. You are working as electrician in motorhomes department of Environments. You have submitted false allegations to the management claiming wages for the month of August and November 1995. You have also made false allegations against Sri so and so, Sri Sellappa and Sri G. Krishna Naidu, timekeeper, and also made allegations against the next incoming general manager and personal manager. It is reported that you have drawn wages of these.
So for 3 years, 3 charges, 4 charges, and you were taken. Disciplinary inquiry was held together for all these charges.
No, separate inquiries. But now, as far as the first charge sheet is concerned, only one portion of the charge is proved. Then
one portion, no?
One part of the charge is mentioned in the first paragraph at page 23. Then, as far as charge number 2 and 4 are concerned, inquiry was held, joint inquiry was held.
Charge number 2 and
4. Now, what happened was on 23/2/2007, the inquiry was constituted. 23/2/2007. Just before one day, that is on 22/2/2007, I had to go to Vellore to attend an ailing relative. So, immediately I sent a fax to the management saying that, on account of unforeseen situation, I have to go to Vellore. Not only I submitted a representation, I sent facts, and then Lord, I also produced a train ticket for having undertaken the journey. Nonetheless, Lord, I was placed ex parte on 23/2/2007.
Where is that order?
Lord, that order. Lord, please have a look at. Lord, page 46. First paragraph.
Yes.
I'll read Lord about the 6 lines from the bottom of first paragraph. Copies of the documents. Copies of the documents and list of witnesses were published in the charge sheet employee. The management examined one witness and filed some documents and they were marked as so and so. Opportunity was given to the charge sheet employee to cross-examine the management witnesses, but he has not availed the same in spite of giving sufficient opportunity. Therefore, it was placed ex parte and the inquiry concluded on 2007. But before that, I have also produced the facts message and the representation for having submitted the request to adjourn the inquiry. As a matter of fact, your receipt of all these notes has been admitted by the management in the cross examination. That was not in connection with the validity of the inquiry. But page 39, annexure G is the representation which I have submitted on 23/2/2007. Then page 40 note are the 2 train tickets.
This was all produced before the inquiry officer?
Yes, not only before the inquiry officer, even before the labor court also, I had produced. Now note, please have a look at page 99. Paragraph 17. Note, this is the cross examination of the management witness. Paragraph 17. It is true that on 28/11/2006, first party requested for payment for the agreement. Witness adds that he has been doing on 28/11. It's true that first party had sought adjournment of the inquiry proceedings dated 23/2007 by sending facts. But I do not know whether he had also sent telegram and letter to the witness adds that on 23/2/2007, after hearing of this second party, I have placed first party. Then please turn to the next page, paragraph 19.
No, disciplinary inquiry has held fair and proper. Huh?
Yes, sir. Now please turn to paragraph 19. It is more categorical here. It is not correct to suggest that the last sitting of inquiry was on 21/4/2006. It is true that on 23/2/2007, first party has sent a catch message, telegram, and registered letter seeking adjournment on some inquiry. It is true that I did not grant adjournment and close the inquiry because that was given previous power. So, notwithstanding this admission, ultimately the labor court holds that inquiry is fair and proper, and eventually you pass as an award. This is my temporary against which I am.
Now, if the inquiry is held without considering all those documents, now
Yes.
the order of holding the inquiry is fair and proper has to be set aside, then has to go, and then you have to be directed to them to hold an inquiry against you again at this stage.
So what happened is you are now being already 18 days and now it's also good. Not all my colleagues have been granted VRS benefits in the meanwhile.
Instead of termination, you should have been given VRS.
Whatever benefit which has been extended to my
What was the benefit which was given to them?
benefits that have been paid.
Ultimately, even if you look into all these aspects, it would not serve your purpose of going back and holding an inquiry.
Yes. Then the tenor of these charges, not more reasonable and too late employers have indicated this.
It's not so serious enough for them to hold an or remove you from service of by order of termination. When was the order of termination passed?
Yes, pass. So, 12/3/2007.
When is the closure of the company?
Very subsequent. Not on the exact date. It is there is no issue. But the last of
The establishment is closed. Yes.
Number the reasoning later put in one paragraph for 20, I will read page 148. Paragraph 15 of the above.
Paragraph
Paragraph 15.
1.5.
148. Even it is also admitted that all the workers who are working in the second party have been given the benefits of voluntary retirements. Except this, he has not produced any iota of problem that the dismissal or the past.
So during the pendency of the labor court itself, there was a closure of this. So you say whatever benefit of VRS scheme that the other benefits have been processed.
Fortunately, the labor court comes to the conclusion that I did not produce any document to establish that the penalties.
That is not disputed by the other side. They don't dispute that they have paid certain VRS amount to the other. They don't dispute. There is a question of saying. Yes. Yes, Mr. Swami. For the petitioner in part, Subramania Bhatt for the petitioner in part. Is there no representation on behalf of the respondent? In order to afford an opportunity. Discuss matter tomorrow. Further hearing. Further hearing. Yes. Harish Pandari. Senior was here.
The last matter which is there at 4 o'clock.
What is the misconduct?
8 passengers.
Non-issue. How many times you have been issued with this? You have, they have not produced the history sheet. So there is an history sheet against you. Where is the question of proving that that is already an admitted document of yours? You don't dispute exhibit 1021. No, what do you expect the corporation to prove that this is not? So that is one thing. You have to substantiate that you were not involved in similar filtrate of revenue of the corporation. And the history sheet which was issued in you, which was issued was not pertaining to you. Is it your contention? It is not. That is not available. That is not available to the workman to say that, because he would be aware as to what were the misconducts which was leveled against. Fine. Yes. That is similarly placed workmen wherein they were imposed with a minor punishment.
Examining one Sampangli Ramaswamy, the cross examination, he admitted that it will change and not prepared by him.
History sheet need not even be served upon you, because it would be you would be well aware about what was the misconduct which was leveled against you. This is not nothing like unaware. Are you being superannuated now, or are you still working with the?
Informed that the file has been taken over by the parties. That's how they were coming at that.
For the BMPC.
Yes, Lordship. I informed the BMPC, but the other side had informed my senior just now that the other side, the party has taken back the file.
Making a submission on the weakness of the respondent.
Not on the weakness, Lordship, but now my senior is set up in another court call.
You're Shankrapa or are you Nishan? So Shankrapa doesn't appear any longer in this petition. Registry to delete the name of Shankrapa as counsel appearing for respondent number 1A, since Nishan EK has filed power for respondent 1A. This matter at request of the petitioner counsel tomorrow. Who appears for this party in person? Is he here before the court? Yes.
What matter?
Misconduct, what is the misconduct?
The labor court granted court services for an if it is not already paid, you pay the same. That I have paid as per annexure B and C. Now, despite this, the recovery certificate was made to an order passed on the 33 once the award of the labor court not implemented. He goes before the deputy commissioner. The deputy commissioner should issue recovery certificate. This is a motion to the operating. I think the annexure A is there. The operating portion, I take your document. Page 20. Before that, I just read one line in the 4 lines in page 19. If your notion comes in the 4th line further.
Yes.
Labor Commissioner and the what are all the payments made to the applicant? and paid them only rupees 42,781 is due to him. However, it is also important to note that the respondent has contended that even the said amount was paid to the applicant along with interest at the rate of 2%, that is in total 16,816 as per the article. Though the applicant has denied receiving the arrears of amount so and so, he has not made a supportive documents with regard to the but he has not examined the article 1 to contradict the context in the documents produced with the other first. And the reasons of the I opine that the applicant is entitled to arrears of rupees 42,781 interest at the rate of 10% per annum to the payment of superannuation. That is but this wording may not be like this. Operating motion. Application filed by the applicant at section 30 is partly allowed. Applicant is entitled to receive 42,781 interest at the rate of 10% per annum. From 3,000 and prepayment is not paid. Now, it's not paid. If your lordship puts connection B, he goes before the Assistant Labour Commissioner. The Assistant Labour Commissioner directs, I think up to page 30, page 30, operative portion. A direction is made to pay 42,781.
When was this order passed by the Labour Commissioner?
By the Labour Commissioner.
After the order,
11/1/2010.
first he goes before the Labour Commissioner.
That's what I submitted in 33C proceeding that I've already paid. That is recorded in page 19. I released your lordship. The order I did. Can you come to page 30? Page 30, your lordship will see amount page 34 line operating portion. 42,781. With interest like 10%. So total amount is 290 we paid. But this is paid. Technical connection. This is reviewed by photographer. It is so the controlling authority is to furnish this photograph. With photograph, they show the disbursement amount. This is by white check, they take 17,000. This is disbursement. And now the reviewed order is issued. And connection D with the notice saying that you have not paid this amount pursuant to the annexion A order, which I find objections as per annexion E. And furnish all these documents to show that, especially page 37, para 9 of the objection statement before the recovery officer. I brought to their notice that I have already paid this. Despite this, annexion F, they reviewed all of this.
Next F is the order passed by the
And in fact, on 17/6/2019, this order was directed respondent to file an affidavit as regard to the annexion C payment. 17/6/2019. Interim order was extended until the disposal of the repetition, and there is a direction for to file an affidavit regarding annexion C payment.
17/6/2019. He has not filed an affidavit to that. For the learned counsel for the petitioner in part. Party in person is not present. This is the matter for further hearing on Thursday. On 17. Registry to intimate the party in person telephonic. Yes. On 20. 21st, yes. Right. You are ready in that 2:30? Keep going. You are ready in this matter? Who appears for the respondent? Mr. Mukkanappa? 2:30 matter. We'll take up 2:30 matter. Takela matters. How much time will you take, Mr.
Not more than.
Sorry, Mr. Anthony, it is for the South. So other matters we can add. Other matters. Your matter, when do you want? Sorry, all on 17 and then 23, 24. Process 37 will be taking up on 17, huh? 51, when do you want? 17. 46, interim order granted earlier is extended till the next date. Yours is? ಯಾವಾಗ ಬೇಕು? Interim order, interim relief ಕೊಟ್ಟಿದ್ದಾರಾ? 17th. Day after tomorrow. Next week, this week we are taking second appeals again, Thursday, Friday. So to 17, 38 on 17. When do you want, Mr. After the 24th. ಏನಾಯ್ತು? ರಿಟ್ ಪಿಟಿಷನ್ ಅಲೌಡ್ ಮೆಮೊ ಅದರಲ್ಲಿನೂ ಹಾಕಿದಾರಲ್ಲ ಅನೆಪ್ನು 44 ನಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ is allowed. Rit petition is allowed. Impugned order passed by the Labor Court is set aside. The order of the disciplinary authority stands confirmed. Memo is filed stating that after the order passed by this court directing to reinstate the respondent, which would be subject to the result of the writ petition, the respondent has remained absent, and on account of that, disciplinary inquiry was conducted, and he has now been dismissed from service, removed from service, and the said memo is taken on record. Memo writ petition, the order sheet. 49, 49/17. Add matters to 53, 17, 17. Yes. ಅದೆಲ್ಲ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಯಾರಿದ್ರೆ ಅವ್ರು ಬೇಕು. ಎಸ್. Other side was pressing. Yes, yes. But sitting, the sports is still 5:30. Anyway, that was on the other sides mentioned. We have listed it today.
Just the final order just in serial application 49 of 2003, dated 13/8/2013, should find that order at page 158.
This is 33 to be approval.
Not 33 to be approval application has been rejected.
Yes.
In a brief, do not have to just explain what this is, and then I will take a look through the relevant paragraph. Without charge sheets were issued. Annexure A and annexure B.
Just a minute. Okay. Yes.
Because that is considered. Not the qualification, then the target was very good. Without a common order of punishment of from Terminal report on 19/11/2003, which is election 6. Now, Lord, since
How many workmen involved?
Lord, in this case only one.
Only one.
Yes. Now, Lord, the annexure C, if you not see, is a common order, page 30. It refers to both the charge sheets, expression, and the inquiry report. It's a common inquiry report. Now, Lord, at para 11, page 36. Considering the above, the appropriate punishment for the cruel misconduct is accordingly, I hereby dismiss you from the services of the company on each of the proved charges in both the inquiries immediately. Consequently, you also stand reviewed for service. Since an industrial dispute, not since an industrial dispute, next page, not paragraph. Since an industrial dispute is pending adjudication before the industrial tribunal, in which you are a concerned one in the dispute, we have filed an application before the tribunal today seeking approval of the action of your dismissal company. And along with that, Lord, the para 13, we have offered 1 month's wages. Now, Lord, the labor court proceeds to hold that the inquiry that was held is fair and proper. Lord, on the question of findings recorded by the inquiry officer in respect of both charge sheets, the tribunal also holds that there is nothing to hold that it is perverse. I will take a watch. It records a finding that the finding recorded by the inquiry officer is also fair and proper and justified. But then the Lord rejects the application for approval on the ground that the application ought to have been filed seeking express prior permission under 33(1)(b) and not 33(2)(b) on the basis that the allegations made in the charge sheet dated 2/5/2000, that is the second charge sheet, is connected with a dispute which is pending before the labor court, before the industrial tribunal, that ID 138 of 2000. The tribunal comes to the conclusion that the second charge, the allegations made therein are connected with a dispute which is pending adjudication under 138, and therefore, under subsection 1(b) of section 33, the labor tribunal holds that it should have filed an application seeking express permission and not seek approval. 33(1)(b) may kindly be seen now. But condition 33, conditions of service, etc. to remain unchanged under certain circumstances during pendency proceedings. 1. During the pendency of any consideration proceeding before consideration or a board, or of any proceeding before an arbitrator or lower court or magistrate, no employer shall, in regard to matters connected with the dispute, alter this we are not concerned. B. For any misconduct connected with the dispute, discharge or punish, whether by dismissal or otherwise, anyone concerned in such dispute, save with the express permission in writing of the authority for which the proceeding is pending. Now, Lord, the tribunal has recorded a finding that the misconduct in charge sheet 2 relates is connected with the dispute which is pending in the ID1, and therefore approval is not permissible. It should be except permission under 33, and because of that, the application has been rejected. So, Lord, my submission 3-4 hours. So, Lord, the labor court also, the tribunal also refers to a few other orders passed in respect of other workmen, where similar charge sheets were issued to them. And Milord, that was called in question in the rectification also, and writ appeal also, and then Milord, one of them went to Supreme Court. But then Milord, there the court holds that it should have been 33(1)(b) and not B. Now, Milord, my response submission here also on those aspects. Now, Milord, that would not operate under a suit. Because that is in respect of different parties. This is in respect of the respondent hearing.
Was the misconduct
Misconduct, but then they are all different misconducts. Maybe, what happened was, there was unrest, which ultimately led to a lockout. Now, my lord, the reference was pertaining to lockout. 138, the management is justified in declaring a lockout. And my lord, the issue is whether the workmen were on strike. The issue regarding specific misconduct that we have alleged against the workmen here was not part of the inquiry or part of the adjudication in that reference. That has not been touched upon or decided, therefore it is not connected. Maybe, Lord, ultimately their actions may have led to, but then, Lord, what was referred for adjudication is whether management is justified in declaring a lockout. Now, Lord, as an ancillary to that, court did not go into the question as to whether involvement of each workman. Court only went into the question as to whether there was concerted action and whether it amounts to a strike. That is something different, and that has nothing to do with individual charges. Now, my lord, in fact, on that score, my request submission to lodge that if there is no such connection, then we will come to the conclusion that it is the misconduct is directly relates to the allegations made in the charge sheet, and then if that is referred for adjudication, that is not so. I will take a lordship to that also. Therefore, my request submission is in the first place, my first submission is that the finding for the tribunal that the misconduct is connected and therefore the provisions of 33(1)(b) would apply is misconceived. In fact, on that I have a written judgment of the Supreme Court that is a fact. I will take notice to that. Yeah. That is what. Now the second aspect is this. The second aspect is this. Lord, admittedly, this is a composite punishment in respect of two charges.
Yes.
11,11,99 to 5,000. assuming for a moment that one of the charge sheets, allegations made in the charge sheet in one of them, has some nexus to the dispute which is referred, that is ID 138. But then, my lord, the other charge sheet has nothing to do with the ID 138. Therefore, this is a composite punishment in respect of both. Now, my lord, in respect of the other charge sheet, I am legally entitled to maintain a petition under 33(2)(b) because it is not directly or indirectly connected with the pending dispute. But then, because there is general dispute pending under 138, I am only required to seek approval under 33(2)(b). So let us ignore one charge sheet, but at least in respect of one charge sheet, now, my lord, I have a right to file under 33(2)(b). Therefore, my lord, the doctrine of election comes in here. When I have a choice to either go under 33(1)(b) or 33(2)(b), and when the Industrial Disputes Act does not say or prohibit, the Act must prohibit. Otherwise, election is for the person who approaches. Now, my lord, the Act does not say that if it is a composite punishment in respect of two charge sheets, and if it is permissible to file 33(2)(b) or 33(1)(b), you should only file under 33(1)(b) and not under 33(2)(b). There is no such non-obstante clause in the Industrial Disputes Act. Therefore, my lord, the doctrine of election, I have some judgments on that, I have already filed that. So, the doctrine of election comes into me. And if I exercise that and then file 33(1)(b), 33(2)(b), my lord, court should not say, a tribunal could not have said that 33(2)(b) is not maintainable at all. 33(2)(b) is maintainable. That has not been gone into by the tribunal at all.
According to you, either you could maintain 33(1)(b) or 33(2)(b).
So if, and in fact, that is assuming that the second charge sheet allegations have connection with is connected with the Refund. That again, I am disputing that I take it up. Therefore, even otherwise, when doctrine of election gives me the right, when I take that right, now, my lord, the labor court should have granted approval. And the other aspect is, now, my lord, what is the purpose and object of 33(2) or 33? 33 only. Whether 1B or 2B or 3B. 3B relates to, my lord, a protected worker. Now, my lord, your lordships are aware that 33 has a limited concept. 33 is that when a general dispute is pending before any court or consideration dispute, or before it must be specific thing. And it should not be open to the employer to victimize because of participation in that industrial dispute or a proceeding which is pending. And therefore, a protection is given to them, saying that if you want to dismiss somebody when a dispute is pending before you, please take approval if it is not connected. If it is connected, seek permission. Now, Lord, the scope of interference in a 33 proceeding, whether it is under 1B or 2B, is extremely limited, as you know. There are several judgments having applicable options. Therefore, the tribunal or the labor court, before whom the application is seeking approval or permission, what is only required to see, I must see whether the inquiry has been held properly. Once it comes to a conclusion that the inquiry is held properly, now, my lord, it almost leads to a conclusion that court will not interfere with the ending, unless, my lord, it is imposed as a condition of victimization. Now, my lord, what is victimization? There must be pleadings as held by the Supreme Court in other time works by the fair. So, Lord, that must be a reading. But there again, Lord, the Supreme Court says, if the charge is held from, the Lord, question of victimization fails into insignificance because proof of misconduct is antithesis to the plea of victimization. Therefore, Lord, once inquiry is held here, and court does not find any perversity in the then Lord, it is automatic that either permission or approval for be granted. And Lord, permission granted either under 1B or 2B approval is not final. It is only temporary. It is not final. That Lord, the Honorable Supreme Court.
The granting of permission or approval
Yes.
to the employer
Yes.
is like keeping the order under suspension, or rather you have been dismissed from service and you are not entitled for any benefits during that
Right now. That does not become final. In fact, after that, the employee has a right, but one has a right to raise the dispute. Earlier, 2A was not there. Therefore, it had to go through the union, especially individual disputes. Then, amendment came in, and then 2A, it was permitted by the individual worker who was being terminated from service to approach the court. Then, 10-4A came in. 10-4A brings in another improvement there to say that worker directly can approach without the incidence of cancellation, can approach within 6 months of the date of the order of termination. Therefore, these are the changes which came about. Now, the Supreme Court, in fact, one judgment I will take in to show which is Workman of Mysore Lamps versus State of Karnataka. Lordship Justice, Navajot Justice. Page 803, Your Lordship.
Yes. 10.
803,
Yes.
Paragraph number, after paragraph 5, the last paragraph. The scope of powers and jurisdiction of the Industrial Tribunal and the Labour Court under section 23 of the Act have been expounded in the following decisions. They are referred to Mackenzie, Caste and Jain, Delhi Clockmans, Lalaram, Tribunal. I shall set up the relevant paragraphs of the judgment in the case of Delhi General Law Mills, which arose out of proceeding under 33. Para 21 has been extracted, para 21 and 22. And the 23. Because very notable to the Lordship permit.
Yes.
What has happened here is, after referring to all this, scope and powers of that the judge proceeds to roll. That 33 is redundant. They should remove it from the. It has not happened yet. But then, the 33, the purpose is different. And it is not serving the purpose, especially when they refer to that. Now you have to go directly. You don't have to go to conciliation. That's what was said way back in 84. Before we proceed to deal with the contention of Mr. Alan, it is necessary to state the law regarding the nature we have occasion to deal with a similar decisions. Observed daily, the nature of jurisdiction exercised by an industrial tribunal is very limited. And it has been laid down by several decisions of this court. The position is that where a proper inquiry has been held,
the tribunal has to accept the finding by the inquiry, unless it is perverse or unreasonable. And to give or unless the reason to be management is guilty of victimization or has been guilty of unfair labor practice or is acting in harm. Then in Martin Burn and so on so, it has been laid down that once a tribunal, individual tribunal is satisfied that the conclusion arrived at by Christopher officer on the offence led before it is impossible, the tribunal has no jurisdiction to substitute its own judgment for the judgment of the inquiry officer. Though the tribunal may itself have arrived at a different conclusion of the same material. It is spoken. Then it has been further held, laid down in Lord Vista textile as follows. It is well known that the question about adequacy of evidence or its sufficiency or satisfactory character can be raised in a court of facts and may fall to be considered by an appellate court, which is entitled to consider facts. But these considerations are irrelevant when the jurisdiction report is limited in section. It is conceivable that even in holding an inquiry under section 33(2), if the authority is satisfied that the finding recorded in the inquiry is perverse, in the sense that it is not justified by any legal evidence, whatever, only in such cases it may be entitled to consider whether approval should be accorded to the employer or not. But it is essential to bear in mind the difference between a finding which is not supported by any legal evidence and a finding which may appear to be not supported by sufficient or adequate or satisfactory. We may also refer to decision of Central Bank of India and versus Prakash Jain, where after a reference to the principles laid down in AR 1961, 860, that is Lord Krishna textile, where it has been pointed out that test of perversity of a finding recorded by a tribunal or an inquiry officer will be that the said finding is not supported by any legal evidence or. It has been further pointed out that finding recorded by a domestic tribunal, like an inquiry officer, will also be held to be perverse in those cases where the finding arrived by domestic tribunal is one which no reasonable person could have arrived at on the other. The position was summed up by this court in the said decision as follows. Thus, there are two cases where the findings of a domestic tribunal, like the inquiry officer, dealing with disciplinary proceedings against a workman can be interfered with, and these two are cases in which the findings are not based on legal evidence or are such as no reasonable person could have arrived at on the basis of the material before the tribunal. Each of these cases, the findings are considered. From the above decision, the following principles broadly emerge. When the management relies on the inquiry conducted by it and also simultaneously adduces evidence before the tribunal without the inquiry, the duty of the tribunal in the first instance to consider whether inquiry to be elected by the management or not. If the tribunal is satisfied that inquiry has been paid and if the person of considering the evidence before it or the only when tribunal votes that inquiry is not but it denies jurisdiction to deal with the direction. In that case, it has to consider the evidence at least equal and decide the matter on this. Not kindly come to. But on page 808, para 12, they have quoted the law laid down in Prakash and Jain's case. Then
What happens in the absence of any domestic inquiry?
Absence of any domestic inquiry or invalid domestic inquiry are treated alike. In fact, the judgment is 73 Supreme Court 1227. That is 1973 Supreme Court AR 1973, Supreme Court, page 27, paragraph 27.
Yes.
Firestone rubber. There, not the Supreme Court, after referring to all judgments, have laid down the procedure that should be followed by a labor court or a industrial tribunal while adjudicating a matter relating to termination.
If there is no domestic inquiry, the management is at liberty to lead evidence independence.
There will not, in either case, whether where inquiry is held, the labor court or tribunal is required to frame a particular issue, record a finding there. If the inquiry is held in the affirmative, then will not the labor court, now in view of the powers conferred under 11 capital, will have two aspects. The first aspect is, it can reappraise the evidence in a limited manner. There again will not there is. It cannot sit as a court of appeal. It has a limited role. It will only have to go through the evidence and find out whether there is some material on record for the inquiry officer to come to that. Now, that finding can be held to be perverse, even under section, even while examining it under section. Only under two circumstances. Perversity is only when there is no legal evidence at all on record. Number two, where extraneous material is relied upon to record such a thing. Only under these two. And then if inquiry is not held, or if inquiry is held to not fair and proper, then will not, depending on the plea taken by the employer seeking permission to lead evidence, court will have to grant that permission and allow the management to lead evidence. And then will not, court, even though it may be under 33, court will not be acting within the limited powers while examining the independent evidence. It will be a decision on merits. Therefore, will not, when inquiry is set aside or where there is no inquiry at all, in a proceeding under 33, if the labor court or a tribunal records an independent finding on the basis of evidence adduced before it and records the finding that charge is proved, that operates as res judicata between the parties, even if it is a matter under 33, even subsequently in a matter under section 10, it is not open. In fact, in one of my matters, that issue came in and will not be bench has taken their view. That, in fact, that matter went to Supreme Court. Supreme Court will not had, in fact, said that it's a very interesting issue which has to be decided. But then, the matter got settled. But then it said we will decide this issue in the appropriate proceeding and left it open. But then, division bench judgment was not interfered. Now, recently, the Supreme Court, in another matter, has taken the same view and said it operates.
So, when considering 33 2B,
yes,
the question regarding the merits of the matter can be adjudicated before the
no, if 33 2B will not, if it is on the basis of the domestic inquiry and the findings thereof, control is granted, then everything will be at large, open for the tribunal once the matter comes up before the matter section. None of those findings therein required. But in a 33 proceeding, if inquiry is set aside and parties lead evidence, independent evidence, and the labor court or a tribunal records an independent finding, that finding will operate as a judicata. And therefore, in a subsequent proceeding in section 10, only the second portion of level A would remain. Charge held is proved. Second portion is proportionality of punishment. It's only that which is over. Now we got page 810.
Can you continue some other day?
Yes.
Continue some more. What do you know yesterday? Tuesday will take it. Monday this court will not, sir, because it's a holiday.
Yes, I'm sorry. They are Wednesday.
We'll complete, otherwise it will be quite a distance, we can't even, we'll forget the matter. So we'll take it up on 17th at 2:30. Let them complete their argument. You can address your argument on the next day at 10:30 in the morning hour.
I will complete it also.
17th. This is matter for further hearing. Heard the learned counsel Pradeep Saukar for the petitioner in part to hear further list this matter on 17th at 2:30. 2:30. That will be sitting, we'll be sitting for some more time, he must have thought. That's the whole. Ask the government to come.
One for a short.
Yeah. For this court usually raises late, so I will have a stroll in the corridor. Yes, today we are raising, we had some meet. Ask the gunman to